I've taken the consent of the other side.
Yes.
In this case, I'm being led by Mr. K. Chaudhary. There's some personal difficulty on his side. Can it be anytime next week or after vacation?
Well, after vacation. After vacation,
Deputy Obliged.
at the request of counsel for the petition. Item 37.
I'd like to mention on the listing of a matter today, my lord. An eviction matter, my lord. What happens, my lord? We are the bank, my lord. The owner was informed about the eviction, but we were not. And so ultimately, when the JCB and all are standing right in front of our branch. The only thing is, my lord, we are not seeking any compensation. We are seeking only just time, my lord. Because the valuable lockers and all the important documents are there in the bank, my lord. Madam, today, my lord, eviction, my lord.
May it please your lordship. Pray for listing this matter, lordship, on 19th June. Analogous matter has already been disposed
What
of.
is the matter?
Non-payment of contract clerk.
May I please,
Not 19th, yes, 19th.
may I please, Your Lordship, I will mention for listing of a case, my lord, tomorrow, my lord.
Why?
For motion, my lord. Because I have some personal problem in the next week, my lord. That is why the case was filed in the 11, my lord. And
Yes, no?
case was filed on Tuesday, my lord.
Tuesday.
Yes, my lord.
What is the matter?
My matter is regarding land acquisition, my lord.
Have it next week? Next week? 19th?
May I please, Your Lordship. I beg to mention, Lordship, item number 38, Lordship. For adjournment, Lordship, Mr. H. Gupta, Lordship, conducting counsel is unveiled, Lordship. Let it come after a week, Lordship.
Yeah, please, Your
That
Lordship.
interim order is there.
Lordship, interim order is-
This arbitration matter, the interim order.
There is an interim order.
On Tuesday, my lord.
My lord, till Tuesday, my lord.
On Tuesday, I have no problem, but in the interim order.
Tuesday. All right, Tuesday.
Interim order shall be.
Should we vacate it just now?
You ask him to appear on Tuesday or we vacate it.
My lord, he'll let.
Yes, Tuesday. The request of Mr. Sowenthal and the counsel for the petitioner, Dr. Saraf, appears, assisted by MS.
S. Bhattacharjee.
Yes, Tuesday, 19.
I'm
Obliged.
Interim order.
okay. Till 13.
19th,
Till the next date.
19th. Interim order, continue till the next date. That is 19th.
I beg to mention one listing of case.
Tuesday is 18th, all right, 18th. Sorry.
I beg to mention for listing of the case in Mosoma, Column, my lord. Because there is a demarcation order and it is conducted 202 and 205. But some construction is going on, they have not declared the
Fresh
result.
matter, old matter, new matter,
New matter.
new matter.
Motion.
Uh,
Some of them.
24th,
Oh,
24th.
well, there is an urgency where some construction is going on, so some execution is required. So, my lord, 19, my lord, motion, we have filed already. If not
No,
possible.
no, if there is no defect, it will come. Otherwise,
My lord, sir,
all right,
urgent-
19, 19,
I pray for actually tomorrow, if you are not.
19, all right. Let it be 19.
My
Yes.
lord.
I please, Your Lordship. Lordship, I beg to mention for listing, Lordship. Matter pertains to demarcation of land.
Demarcation, 24th.
I beg to withdraw the IA, Your Lordship, IA number 1335/2024, Your Lordship. For the reason, Your Lordship, that the main writ petitioners, there are 4 writ petitioners, we have included only one person, Your Lordship. So there's some defect, Your Lordship. So Lordship may kindly grant us liberty to file a fresh IA.
Who is the person to be implemented?
Lordship, 3 writ petitioners in the main writ petition, Your Lordship. There are 4 writ petitioners. Writ petitioner number 1 only has been implemented, Your Lordship. The remaining
Who is the writ petitioner one?
Purbanchal Cement, your lordship.
And who are the others?
One is one is another company, your lordship, and two persons are directors, your lordship. One of Purbanchal and one of the other company, your lordship. Northeast.
You file another IA, why do you want to withdraw this? We already issued notice.
That is why, your lordship. So otherwise they would raise objection, it would get delayed. So we'll file a fresh one, your lordship, immediately. Tomorrow itself, we intend. And the matter is next.
If you
week,
want, you
fresh.
file your other IAs. We are not inclined to allow you to withdraw this IA. File fresh IAs. You file fresh IA.
But then this will create a
Why?
hindrance, your lordship.
You are seeking impleadment of one petitioner
Yes,
here.
your lordship.
Other two, you file another IA.
No,
Where's the
only
bar?
one writ petition, your lordship. Only one writ petitioner. Only one petition for impleadment, your lordship. So in the main writ petition, there are
How many writ petitions are there?
There are one writ petition only.
Ah.
where
There were actually two writ petitions. The writ petition they are seeking impleadment. In that writ petition, there are four writ petitioners. We did not get any copy. What I understand is that they have made only one writ petitioner as party. The other three writ petitioners are not party. That's what
they're necessary respondents, your lordship, in the IA.
they could file an IA to that effect, impleading the
That would be an
That's what
IA in another IA, your
yes.
lordship.
Lord.
That would have to be an IA in another IA, your lordship.
No,
No,
it's an IA in the writ petition. Second IA,
second IA in the
you file.
But
no lordship. Then again, since they are not impleaded in the writ petition, there will be a problem
Complication, your
complication. So it has to be withdrawn. Since they are not impleaded in the writ petition as it.
At the request of Mr. S. Day, Learned Counsel, IA number 1335 of so and so stands withdrawn. And the same is dismissed.
Lordship, my name may be recorded. Ajay Das on
Ajay
behalf
Das
of
appears for-
respondent 6
Writ petitioner.
writ petition.
Writ petitioner.
In the IA, it is respondent 6.
In the IA, respondent 6, in the he appears for the writ petitioner in WPT Swin.
liberty may be granted to file a
You don't require liberty, you can file it.
lordship. That may kindly be observed, your lordship, because that some objection may be there. Then.
What objection? You are seeking impleadment of a party. You
Yes.
can implead any anytime, any party.
The same applicant. Your
Liberty is permitted. File fresh.
Deeply obliged.
most of them.
We should we should impose a cost
Lordship.
for wastage of judicial time. You
In
file
fact,
one, we
Lordship,
issue notice. Then you want to withdraw it, then you want to file another one.
Lordship, in fact, they have filed again another IA also had been filed and withdrawn at the earlier stage.
No, that was a different petitioner.
It's like different name
No,
names
but how
are
could you not implead the necessary parties?
Lordship, that was an error on our part, your lordship. I apologize for that, your lordship.
Your apology by itself will not give us the time which you spent in dealing with your application in the matter.
The writ petitioner was substantially heard on that date, your lordship.
All right.
deeply
Much
obliged.
obliged.
So please, your lordship. Lordship, we need 1 week of time to file our affidavit.
On the last day, they were made a request to produce the records. Which is that matter, Lordship, I pleaded that my business operations were closed down. So though they said that they have given notice, but I never received the same. They said they will produce records.
Yes. Place the records in original. That's what you are supposed to do, not file affidavit.
Yes, we need 1 week of time
Why?
for the.
Do it by 19th.
Mm.
Do it by 19th. List the matter on 19th, on which date the Standing Council GST will produce the records as directed in the earlier order dated 3/6/2024. MS so appearing on behalf of the Standing Council submits that the council is not, that the records are not available as on date. Mr. T. Saraf appears for the writ petition.
Much obliged.
In this case, the hearing was closed, Your Worship. will be definitely delivered.
Yes, this is that
But the-
cancellation.
Industry which was closed down,
I was placed on record lordship with operational guidelines. Last occasion lordship, I have showed a couple of provisions from the operational guidelines. So that I'm placing the operational guidelines.
So we close it.
Yes, lordship, I had to only point out those provisions in the operational guideline. But like one is lordship that that application has to be submitted within 6 months of time of commercial production. Then lordship, I have pointed out those formats. I have flag marked in lordship there.
What do you want to produce? What do you want to refer from this?
There are lordship, this flag mark is there.
Hmm.
First is lordship that first page lordship will find that flag marked one, that application has to be filed within 6 months.
6 months.
Chapter 2 lordship will find there.
Yeah.
Then lordship, if lordship goes to page 15,
Yes.
15 lordship, that is enquiry report. The
Yes.
enquiry report lordship, I have shown at page 16, if I may take your lordship. Page 16 lordship will find it on the bottom that the certificate has to be given by the general manager, and certificate the contents of the certificate is certified that I have examined all the particulars furnished in the application together with all relevant documents, and after physical verification I certify that there is no scope for any doubt about the correctness of the particulars of so and so. Then lordship, some amount has to be recommended, that's there in the bottom. So this could not be done because the industry was closed down. So then lordship will find page 17 and 18. 18 also, the lordship will find the statement of investment on plant machinery and equipment, page 17. So basically,
This is to be furnished by whom?
this is to be furnished by the industries department, GM, who will do the physical verification inquiry. So here also lordship will find down bottom, page 18, the certified that we have personally verified the above particulars with original documents produced before us and found those to be correct in all respect. Also certified that the machinery, equipment, electrical items, other fixed assets, etc., as stated above, have already been commissioned and functioning
Now,
at the factory outside.
when they visited it, they found it to be closed.
Closed, lordship.
But in the order of the
The speaking order, lordship.
yes,
The
the
speaking order, lordship,
committee,
basically.
what is that? High level committee.
Yes, Lord.
There is- what-
Speaking order was passed by lordship. This thing, commissioner.
Where is that order?
That is at page 181. Lordship.
181.
So commissioner of industry.
No, 181 is the assessment order.
No, 181 lordship. That case number lordship 1828 lordship 1828.
Hmm?
This was the case we argued the other day. 1828.
182. WPC.
The first item.
Yes.
Page 181 lordship. It basically stated that it's non-functioning. Though they have written couple of lines, of course, lordship, but it's non-functioning. Page 181 lordship.
No, no. In the second paragraph,
Yes, lordship.
you have indicated the date of commercial production as so and so.
Correct, lordship.
Now, on what basis has this been indicated? On what basis that they've started commercial production?
They have, they have submitted their application for this subsidy, wherein they have mentioned that 18/6/2009 is a commercial production, and that was verified, commercial production.
But
But they have not submitted the application within 6 months that was necessary. And secondly, when the,
no. This is the finding by the commissioner,
this is the speaking order because of Honorable High Court has
directed.
directed that speaking order to be passed.
So the commissioner in his order has held that they started, they had commenced the commercial production on
18/6/2009, there is no dispute about that.
Hmm.
But when the verification was supposed to be done, because they have submitted their application in 2016. Commercial production happened in 18/6/2009, but they submitted because of certain reasons, because one matter was pending before the High Court. So that was the reason they have taken. So they have filed the application in 2016, and when we went to the unit, the unit was found to be closed. So we could not verify it. So that is what it has been stated there. However, a non-functioning unit neither contributes. So basically it says about that it is closed.
All right.
And Lordship, that case laws, Lordship, like my learned senior has submitted, I have already distinguished, because in those two cases, already that verification was done, and there was there was an intimation saying that verification was done, and at that point of time, it was running. So prior to that, whatever the subsidies they have claimed for, those were cleared.
That Duroply and
Correct.
Supermoy.
Correct, Lordship, correct.
Only one thing, Milord. My learned friend is saying, in the order it is also mentioned that the unit was non-functional. Non-functional and not in existence are two different things. They were never said that the unit was not there at all. The unit was not functional does not mean the unit was not there at all. If the commencement of production was started, it has not started in the air without machinery, without all those things. Now, when they went there, have they said that nothing was there? They say it was not functional. May not be functional. An industry is there which is not functional. Does it mean that nothing is there?
But if you are not functional, how will the industry determine whether you satisfy the requirement?
Whether the investment is there, machineries are there or not, they could not verify. What is to be satisfied? Well, what is to be satisfied is that whatever I've given, that these machineries, these things are there. They have to see whether these were there or not.
They haven't challenged their operational guidelines. That
Please, now you are
Yeah.
again and again repeating the same thing. You may bring anything, operational guidelines, anything which has no relevance.
No, whether it's relevance or not, the court,
Then
court
you
has
can-
to
you
say.
are-
Court has to see. I'll have to
So
submit.
why you are,
I'll have to say that, like,
why you
operational
are
guidelines were not.
either you make submissions again or you complete again and again.
I'm just saying that operational guidelines.
How many
not
times
there.
you will say? There will no end.
I'm concluded, Lord. So I'm concluded.
Then please,
I don't have anything else to submit. I'm just,
the court has noted your arguments.
I'm just summing up that operational guidelines were not challenged.
Tomorrow he may say the Constitution of India article has not been challenged. Something which has no relevance.
All right. Heard. Councils reserved.
Oblige, Lord.
In one court, he's saying that operational guidelines has no value. Another case is going on there.
Who is saying it's not value?
Here he's saying the operational guidelines binding.
We only
The
take
doctrine.
on record what is stated in this court.
No, my lord.
I
somewhere-
stated there, Lordship, that delegated legislation, that's a different context altogether.
no,
I am not
I
saying it's not
understand.
value.
I
Lordship, I
understand.
mean, this is not.
This is the way the things
This
are
is
going
not
on.
expected. It is not expected. I mean, that was a different context
In
altogether.
everything is different context. Everything is different.
Before this judgment is delivered, if that order is passed, you may place it before this court.
Yes, yes, yes.
My lord, the
Yes.
question is, in that case also, my lord, which he
That's
placed
a
party
different
judgment, he appeared. himself, he made submissions.
Yes, yes.
And now again, he said that in different context. My lord.
All the cases, facts are different.
Well, facts are
Contexts are
always,
different.
facts are always different. There is no doubt about it.
Always different.
So now, in these series, you tell us the matters which,
Well, I have prepared chart,
Ah.
and if you'll also permit me, you'll also close it. I may file a written submission.
yes, both parties, you may
And
file.
along with that, will I give a chart also, that which are the eligibility certificate, which are assessed.
Right.
I'll submit a one note of bullet points. But
My lord, he may be industry department bullet points, I have no bullets. So, my lord, I will file my written submission, I have no bullets. My lord.
Tax, finance department,
Lordship, our argument is simple, Lordship.
Dependent on the,
Depending on the determination by your Lordship on the eligibility, issuance of the eligibility
my
certificate.
lord, if the five
Since it
petitions,
was not submitted, we had to assess it, otherwise.
my lord, if the five petition of the eligibility certificate are
but-
decided this way,
but-
that way,
but if you assess, you have assessed tax.
Yes, Lord.
This is, what tax is this?
CST.
Sales tax.
Sales tax.
VAT, basically.
So sales tax VAT can only be levied when there is a sale. There can be a sale if there is a production. There
Yes,
can be a production only if the unit is operating.
Lordship, for the period they have submitted the returns and their whatever their production, their
No.
notif.
As
mentioned.
far as the finance department is concerned, you have
Yes, sir.
taxed because they do not have the exemption. Now for them, for you to tax, you must come to a finding that this industry is actually operating. For it to produce and sell so that you can earn your taxes. But this is contrary to the finding of the industry
no,
department.
Lordship, there is one catch there. Because industries department has to, in the eligibility certificate, recommend certain amount. So the recommendation will
No,
be
no.
based on the plant and machinery,
That is with
which are
regard to the
functioning.
exemption. That is with regard
Correct,
to the
correct,
exemption.
So
They may not be entitled to the exemption. But by implication of the finance department, will it not mean that the industry is functioning?
no, that's
Well, I will submit. my lord. If I succeed in the eligibility certificate, I will get exemption. If I don't succeed in the first petition, that the factory was not in operation, then I've challenged the assessment orders. The tax which has been levied is illegal because the factory was not in operation. So both sides, my lord,
We'll see.
I have to get a relief from the,
10 months.
I'm not concerned with the eligibility. I have to get a relief from the assessment orders. So if my Mr. Kalitaj's arguments are accepted, it's all right, my lord. The factory is not in operation, was not there at all.
no, I never said it. The industry was not there.
Then I say.
I never said so.
It was there on,
I never said so.
if you recall it that he had never said the factory
never
was in
said.
existence.
I never said so.
All right. We have heard now.
My,
Arguments are concluded.
my,
Yes.
It's
Like
not
it
being
is
interpreted.
2 days time to file your written argument.
no, 2 days, he can file a bullet petition, let him give 7 days.
Right.
I'll also take 7 days then.
All right.
For bullet points, why you need? You have got AK-46, 45, I don't have.
I have bullets, but you have AK-47.
Without bullets, what I will do?
Well, whether it is bullets or cannonballs, you are all hurling it at me.
Okay.
I'm-
Oblige, sir.
Yes, Mr. Goel.
My lord, my lord, these five writ petitions. In these writ petitions, we have challenged the notices issued under section 148 of the Income Tax Act 1960. My lord, last time when the case was heard, the lead case which was taken is WPC number 7103,
03
Mukund Infrastructure Private.
7103.
My lord, the last order passed was on 9/11/2020 by your lord.
Yes,
My lord, the notice which is under challenge is notice dated 31st March 2017, issued under section 148 of the Income Tax Act 1961 on the ground of total lack of jurisdiction to issue such notice. The notice is at Annexure 8, page 99. My lord.
yes,
Now, my lord,
yes.
Is the lordship. My senior is on legs in other court.
We are permitting the petitioner to argue. Yes,
my lord, under the Income Tax Act, when a return is filed, then the assessment is completed under section 143 of the Income Tax Act 1961. And the income is computed and the tax is finally determined. My lord, however, in certain cases where the assessing officer has reason to believe, as per section 147 of the Act, that certain income has escaped assessment, he may subject to the provisions of section 147 and 140. He may initiate reassessment proceeding by issue of notice under section 148 of the Act. Therefore, my lord, the presence of conditions is laid down in section 147 of the Act are the very foundation or the jurisdictional requirement or assumption of jurisdiction under section 147. My lord, if the foundation is not there, then the whole building collapses. I will take your lordships. And my lord, it has been held by the Honorable Apex Court that initiating reassessment proceeding is a very serious matter. Therefore, it is to be seen that all the requirements of section 147 are met. Section 147, my lord, the entire scheme of reassessment was amended with effect from 1/4/2021, my lord. This is under the old scheme. Now, section 147 was there. I will just read section 147, my lord. If the assessing officer has reason to believe that any income chargeable to tax has escaped assessment or any assessment year, he may subject to the provisions of section 148 to 153 assess or reassess such income and also any other income chargeable to tax which has escaped assessment and which comes to his notice subsequently in course of the proceedings under this section, or recompute the loss or depreciation or allowance or any other allowance, as the case may be, for the assessment year concerned, hereinafter referred in this section, as sections 148 to 153 referred to as the relevant assessment year. My lord, then the proviso is there because the proviso is very important. It is applicable in all the cases here, except one case. In 4 writ petitions, this proviso will be applicable, my lord. Provided that where an assessment under subsection 3 of 143 or this section has been made for the relevant assessment year, no action shall be taken under this section after expiry of the 4 years from the end of the relevant assessment year, unless any income chargeable to tax has escaped assessment for such assessment year by reason of the failure on the part of the assessee to make a return under section 139 or in response to a notice issued under subsection 1 of section 142 or section 148, or to disclose fully and truly all material facts necessary for his assessment for that assessment year. Then, my lord, provided further that nothing contained in this first proviso shall apply in a case where any income in relation to any asset, including financial interest in any entity located outside India, chargeable to tax has escaped assessment for any assessment year. Then, my lord, provided also the assessing officer may assess or reassess such income other than the income involving matters which are subject matters of appeal, reference, or revision, which is chargeable to tax and has escaped assessment. Then, my lord, explanation is there. Explanations are there. My lord, I will once again draw your lordship's kind attention to the first proviso. First proviso, that wherein assessment is completed under section 143(3), no action shall be taken under this section after expiry of the 4 years. Now, in all these cases, assessment year involved is assessment year 10-11 minor. So 4 years have expired on 31st March 2015. All these notices which are under challenge have been issued on 31st, either 30th March or 31st March 2017. All the notices have been issued after 4 years from the end of the assessment year. So therefore, this proviso provides that no action shall be taken under this section after expiry of 4 years from the end of the relevant assessment year, unless the income chargeable to tax has escaped assessment for such assessment year by reason of failure on the part of the assessee to make a return under section 139 or in response to notice under subsection 1 of 142 or 148, or to disclose fully and truly all material facts necessary for his assessment for that assessment year. All these conditions are to be revealed in the regions recorded for issue of notice under section 148. That is the basic requirement.
Yeah.
Then, my lord, if your lordships permit me, I can take your lordships through the entire scheme of reassessment, which is there in section 147 to 153.
Yes.
My lord, then section 148, issue of notice where income has escaped assessment. This provides for issue of notice under section 148. Before making assessment, reassessment, recomputation, under section 147, the assessing officer shall serve on the assessee a notice requiring him to furnish within such period as may be specified in the notice a return of income of his income or the income of any other person in respect of which he is assessable under this act during the previous year corresponding to the relevant assessment year in the prescribed form and verified in the prescribed manner, and setting forth such other particulars as may be prescribed, and the provisions of this act shall apply accordingly. Then, my lord, section 148(2), subsection 2, my lord. 148 subsection 2 provides, my lord, the assessing officer shall, before issuing any notice under this section, shall record his reasons for doing so.
You are reading from
Section 148 2, my lord, subsection 2.
148.
148 subsection 2.
You are reading from which amendment? I mean, which year?
I have 2019 edition.
21 edition, it doesn't have.
No, my lord, then there was a lot of amendments in section 147.
All right.
So whole scheme was changed, my lord.
Okay, okay. But I'll probably find it here. Yes. Subsection 2. Yes.
Subsection.
Yes.
The assessing officer shall,
Hmm.
before issuing any notice under this section, record his reasons for doing so. So therefore, my lord, before issuing the notice, he has to record his reasons, and the reasons recorded by him are justiciable. What was the material before him? What was the live link between the material and the formation of belief that the income has escaped assessment, my lord? So these reasons are justiciable. I'll place before your lordship the reasons recorded also. Then, my lord, the time limit, section 149 is the time limit, my lord. I need not take your lordship through this.
Yeah.
Then sanction of issue, then section 150 is there. Then section 151, sanction for issue of notice. Though we have written to them to provide us a copy of sanction by the prescribed authority, they have not given us a copy, my lord.
No, sanction is required for all cases, or
Sanction is required for issue of notice under section 148. Now there are different categories, pecuniary as well as the time limit. In some cases, it is required from the principal chief commissioner or the chief commissioner or the principal commissioner or the principal commissioner or the commissioner.
where under section 148 is the prescription for a sanction? Ordinarily, the assessing officer has to record his reasons,
His satisfaction.
his satisfaction.
Right. Now, my lord, kindly come to section 151.
151. Yes.
Sanction for issue of notice.
Yeah.
No notice shall be issued under section 148 by an assessing officer after expiry of a period of 4 years from the end of the relevant assessment year, unless the principal chief commissioner or the chief commissioner or principal commissioner or commissioner is satisfied that on the reasons recorded by the assessing officer that it is a fit case for issue of such notice. 151(2), subsection 2, my lord. It says, in a case other than a case falling under subsection 1, no notice shall be issued in section 148 by an assessing officer who is below the rank of joint commissioner unless the joint commissioner is satisfied on the reasons recorded by the assessing officer that it is a fit case for issue of such notice. Subsection 3, my lord. For the purposes of subsection 1 and subsection 2, the principal chief commissioner or the chief commissioner or the principal commissioner or the commissioner or the joint commissioner, as the case may be, being satisfied on the reasons recorded by the assessing officer about fitness of a case for the issue of notice under section 148, need not issue such notice himself.
Yes.
My lord.
Now, my lord, as I have mentioned before your lordship, now this is a case where the notices have been issued after 4 years from the end of the assessment year. And in all these cases, except one, the last case which I will mention, the assessments were completed under section 143(3) of the income tax. That means, my lord, it was a scrutiny case. The assessments were completed after examining the books of account and other relevant documents. And this series of 4 cases, this was a case where income tax search and seizure has taken place. And lot of documents were also seized. While making the assessment, they have examined the entire seized document, and no incriminating material was found regarding escapement of any income which is mentioned in the reasons recorded here. So the first limb is 147. He has to have a reason of belief on the basis of some materials which are available with him. And number 2, and the second limb in this case is that he has to record, he has to make a clear statement in the reasons recorded to the effect that the escapement of income was by reason of my failure to disclose fully and truly all material facts, those were necessary for the purpose of making of my assessment for that year. These are the 2 requirements where a notice has been issued after 4 years from the end of the assessment. Now, and both these conditions are to be satisfied cumulatively. It is not that one condition is satisfied, he will issue the notice. No. He acquires the jurisdiction, only both these conditions are satisfied cumulatively, then only he gets the extension of time up to 6 years for issuing the notice. Otherwise, he does not get made. Now, my lord,
The first, what are the conditions? One is the satisfaction. That
One-
there was an escape.
one is the satisfaction, that is the primary condition under section 147. And the additional condition
Yes.
The additional condition is, my lord, because of the proviso of section 147.
What
First
is-
proviso
what
to
is the
section
What
147,
is the proviso again?
my lord. Provided
Hmm.
where an assessment under subsection 3 of 143 or or this section has been made for the relevant assessment year, no action shall be taken under this section after expiry of 4 years. Am I with you? your
Yes,
lord?
yes.
No action shall be undertaken under this section after expiry of 4 years from the end of the relevant assessment year, unless
Yes.
any income chargeable to tax has escaped assessment
Yes.
for such assessment year by reason of failure on the part of the assessee to make a return under section 139 or in response to a notice issued under subsection 1 of section 142 or section 148
Yes, please. Carry-
or to disclose fully and truly all material facts necessary for his assessment for that assessment year.
Yes.
So, my lord, the second limb of the condition is that he has to show or he has to give a statement in the reasons recorded by him that there was a failure on my part to disclose fully and truly all material facts which were necessary for the assessment. My lord, first, then I will take your lordships
Uh,
through the reasons recorded. And then, my lord, I will place before your lordships to the case laws.
Yes.
The reasons recorded are at page 108, annexure 15.
yes.
My lord. Age per information. It is found that Messrs. Mukund Infrastructure Private Limited, PAN number so and so, raised its capital to the tune of 1 crore and 51 lakhs by allotment of shares with allotment a face value of rupees 10 and premium of rupees 90 full stop. As per the information received, most of the allotee companies are paper companies which exist only on paper with no genuine business of their own. As per the data prepared by DIT Investigation, Kolkata, most of these companies belong to one Sri Narendra Kumar Jain. Sri Narendra Kumar Jain, during the course of survey conducted on 11/4/2014, had sworn under oath that he is an accommodation entry provider who provides bogus accommodation entries, bogus unsecured loan, etc. Then he says, so I have reason to believe that the assessee's income of rupees 1 crore 51 lakhs chargeable to tax for the financial year 2009-10 with relevant to assessment year 2010-11 has escaped assessment within the meaning of section 147 of the IT Act 1961. It is a fit case for issue of notice under section 148 of the Act. Since the case is beyond 4 years, the approval for issue of notice under section 148 is sought from the PCIT Guwahati through proper channel and then signed by the assessing officer.
Well, what is an accommodation entry provider?
Accommodation entry means it is something like I pay cash to somebody who in turn will give me a check. That means conversion of unaccounted money into white money by paying some commission. But without any evidence, my lord. Your lordship will kindly see in the reasons recorded. Age per information. He says only what is the information we don't know. Raise capital of rupees 1 crore 50 lakhs by allotment of shares. Now, as per the information received, most of allotee companies are paper companies which exist only on paper. Now, which are these companies? There are no names of these companies disclosed in the reasons recorded. No names are disclosed. How many shares were allotted to them? What was the date of allotment? What was the face value of shares? How much was the premium charged from them?
Yes.
Then they refer to statement of one Sri Narendra Kumar Jain. Now, we don't know who is Narendra Kumar Jain. We don't know what he has said in his statement, whether he has taken our name. They say he is involved in providing accommodation entries. But whether he has provided any accommodation entry to us, this is not mentioned here, my lord. It is also not mentioned that the funds for the raising share capital were emanated from us. These were our funds. It is not mentioned.
Yes.
So, my lord, and
Yes, please.
my lord, the information regarding allotment of share capital has already been disclosed by us in our audited account. These are annexure 2 at page 82, my lord. We have in our audited accounts, we have already disclosed the capital raised during the year. Kindly see it, page 82, my lord. First page 80, my lord. The balance sheet is there. Page 80 on top, share capital. Last year it was 33 lakhs. This year it is 48 lakhs 10,000. So the share capital raise is 15 lakhs 10,000. And then the next is reserve and surplus. There is a difference of 1 crore 35 lakhs 90,000. That is the premium amount. So total comes to 1 crore 51 lakhs. Then, my lord, at page 82 also, I have disclosed the same thing. Page 82 of my audited accounts.
Yes.
And, my lord, it is a settled law in Corporation Bank's case that once a disclosure is made in the balance sheet, it will tantamount to true and full disclosure. I'll place that judgment before your lordship. So, briefly, my lord, what I've submitted is in the reasons recorded, whatever has been mentioned, there is no allegation that there was a failure on my part to disclose fully and truly all material facts. There is no allegation.
Allegation is there, but there is no material.
There is no material. There is no. No allegation regarding not disclosing or non-disclosing fully and truly all material facts, that is not there.
Okay.
Now, that was necessary to leave that, to lift that embargo that is mentioned in the proviso which I placed before your lordship. कितना पेज पे है? There is not a whisper in the regions recorded. Lordship will kindly come to page 95 now. This is copy of the assessment order for this assessment year. And Lordship will kindly see that at column number 13, section and subsection under which the assessment is made. The assessment was made under section 153C oblique 143(3). 143(3) is the section that is mentioned in the proviso to section 146.
Yeah.
Then, my lord, I will read from the second paragraph. The first paragraph says that there was a search conducted in this group and the names of the firms, etc. are given. Second para, my lord, it says, consequent to the search, the case of the SSC was centralized with the circle by the CIT Guwahati under section 127. Hence, the notice under section 142(1) dated 25/7/2014 was issued and served on the SSC calling for the return of income within 30 days of the service. In pursuance of the notice under section 142(1), the SSC filed its return of income showing total income nil on 8/9/2014. Thereupon, notices under section 143(2), 140 and 142(1) along with requisition was issued and served on the SSC. In response to the above mentioned notices, Sri Rajkumar Sharma, FCS, and Sri Pradeep Kanu, AGM and authorized representatives of the SSC appeared with power of attorney and represented the SSC throughout the scrutiny proceedings. They thereafter appeared on various dates and submitted various documents which were examined and verified. The case was discussed with the AR at length and they were heard. Then, my lord, on perusal of the accounts of the SSC, it reveals that the SSC was engaged renting of immoral properties during the course of assessment proceedings. The seized material was verified and examined. The SSC was asked the explanation with supporting documentary evidence wherever required by the various requisitions, questionnaires attached with the notice under section so and so regarding the entries of transactions in seized material and assets found. On confrontation, the SSC has submitted its replies on various dates, as well as ARs explained the facts during the hearings. The SSC was asked various questions based on various seized material. The SSC's case has been examined with reference to the replies filed and submissions and documents furnished in response to the questionnaire issued and queries raised during the course of hearing. After verifying the income shown and information received, the assessor's total income is computed accepting the returned income as below. Then, my lord, the computation is given. My lord will find that no incriminating material has been found, and my income has been computed as per return. Nothing was found to show that we had taken accommodation entries, we have paid commission. Nothing has been found. All the documents were seized in course of the search. Then, my lord, the last paragraph, kindly see.
Yes, carry on.
This order is passed with the prior approval of the additional commissioner of income tax range for Guwahati, issued under section 153D of the Act, why it is letter number so and so and dated so and so. Not only the assessing officer has examined all the records, accounts, everything. His supervisory officer, that is the additional commissioner, he has also given his approval that he cannot give without examining the records and the assessment prepared by him.
Yes.
My lord, a look at the regions recorded will show that there is no cause and effect relationship between the formation of beliefs and escapement of income. There is no cause and effect relationship.
Yes.
My lord, uh, I will place before your lordship certain settled legal propositions with respect to section 147, 148, my lord. I, with your permission, your lordship, I will submit this compilation of the case note.
Yes. 2 volumes.
So I have tried to place all the,
Why don't you take your seat? Yes.
I have tried to place all the judgments, my lord, of this Honorable High Court on section 147, 148, and as well as the Honorable Apex Court, and also other High Court. Now, my lord, the first proposition is that the recording of regions before issue of notice under section is mandatory.
Yeah.
and these are justiciable.
Yes.
You know. My lord, the first judgment in which I want to place client is that serial number 1 of my compilation of part 1. Hindustan Liver Limited versus RB Vodka. My lord will kindly see at page 4. Page 4 of the compilation, para 20.
Yes.
The regions recorded by the assessing officer nowhere state that there was a failure on the part of the assessee to disclose fully and truly all material facts necessary for the assessment for that year. It is needless to mention that the regions are required to be read as they were recorded by the assessing officer. No substitution or deletion is permissible. No addition can be made to those regions. No inference can be allowed to be drawn
Yes.
no inference can be allowed to be drawn based on regions not recorded. It is for the assessing officer to disclose and open his mind through regions recorded by him. He has to speak through his reasons. It is for the assessing officer to reach to the conclusion as to whether there was any failure on the part of the assessee to disclose fully and truly all material facts necessary for his assessment for the concerned assessment year. It is for the assessing officer to form his opinion. It is for him to put his opinion on record in black and white. The regions recorded should be clear and unambiguous and should not suffer from any vagueness. The regions recorded must disclose his mind. Regions are the manifestation of the mind of the assessing officer. The regions recorded should be self-explanatory and should not be kept the assessee guessing for the regions.
Yes.
The regions provide link between conclusion and evidence. The regions recorded must be based on evidence.
Yes.
The assessing officer in the event of challenge to regions must be able to justify the same based on material available on record. He must disclose the reasons as to which fact or material was not disclosed by the assessee fully and truly necessary for assessment for that assessment year, so as to establish vital link between the regions and the evidence. The vital link is the safeguard against the arbitrary reopening of the concluded assessment. This is the main purpose of the regions which are recorded, my lord. The regions recorded by the assessing officer cannot be supplemented by filing affidavit or making oral submission. Otherwise, the regions which were lacking in the material particulars would get supplemented by the time the matter reaches to the court on the strength of affidavit or oral submission advance.
Yes.
So, my lord, Then, my lord, the second judgment which I place reliance on is Guwahati Metropolitan Development Authority versus CIT, placed at serial number 3 of the compilation. Compilation page 14 and 15, my lord.
Yeah.
Page 14, para 11, my lord. We have carefully considered the submission made by the learned counsel for the parties. The first issue that needs to be considered here is whether initiation of reassessment proceedings under section 147 was justified on material. This section allows the assessing officer to reassess income only if he has reason to believe that income concerned for the concerned assessment year has escaped assessment. The material basis for the reasons to believe will justify the action of the AO to act against a particular assessee. Therefore, it is relevant to determine whether the relevant material existed on which the reasonable person could have formulated the requisite belief to conclude prima facie that the income of the concerned year has escaped assessment. Then, my lord, I come to page 15, para 13. Para 13. Page 15, para 13.
Yes.
Well, I'm sorry, my lord. Para 12 is also important. When the assessing officer takes action under section 147 and issues notice for the reassessment under section 148, he has to record his reasons, and such reasons is subject to judicial scrutiny. The expression reasons to believe was explained in various decisions, and substance of the conclusion in those decisions are called out by our court in CIT versus Shiv Shakti Flour Mills, 327 ITR 430 in the following cases. Now, they have reproduced para 14 of from Shiv Shakti Flour Mills, my lord.
Yes.
The expression reason to believe cannot be discussed in various came to be discussed in various decisions of various high courts as well as the apex court. The apex court in Shivnath Singh has observed that the words reason to believe suggest that the belief must be that of an honest and reasonable person based upon reasonable ground, and though the assessing officer may act on direct or substantial evidence, but he cannot act on mere suspicion, gossip or rumor. It has further been observed that the assessing officer would be acting without jurisdiction if the reason for his belief that the conditions are satisfied does not exist or is not material or relevant to belief required by the section. The apex court has further opined that the court can always examine this aspect, though the declaration or sufficiency of the reasons to believe cannot be investigated by the court. The apex court in Lakmani Mewal Das has observed that the grounds or reasons which led to formation of belief contemplated by section 147 must have a material bearing on the question of escapement of income of the assessee from the assessment. Once there exists reasonable ground for the assessing officer to form the belief, that would be sufficient to clothe him with the jurisdiction. It has been further observed that reason to believe does not mean a purely subjective satisfaction on the part of the assessing officer, and the reason to believe must be held in good faith and cannot be merely a pretense or should not be based on extraneous or irrelevant consideration. There must be a live link between the material and the belief. In Gangasaran and Sons, the apex court has observed that if there is no rational or intelligible nexus between the reasons and the belief, so that on such regions, no one properly instructed on facts and law could reasonably entertain the belief, the conclusion would be inescapable that the assessing officer could not have reason to believe that any part of the income of the assessee had escaped assessment. Then, my lord, I will come to paragraph 13.
I think Lakshmani Mewal Das is the
Yes, my lord.
landmark judgment,
Yes, that is.
still holding field.
I will place the judgment before you. My lord, I'll just read paragraph 13 of the judgment at page 15, my lord.
Yes.
The analysis of the judicial pronouncement as expected above reflects that there must be a live connection between the material on which conclusions are reached by the assessing officer in formation of his belief that income chargeable to tax has escaped assessment. The reasons must be based on bona fide belief and cannot be based upon extraneous material. In other words, there must be a rational and intelligible nexus between the reason and the belief, so that any reasonable person properly instructed on facts and on law can reasonably entertain the belief needed for acting under section 147 of the Act. It is also important that the relevant materials must appear from the order whereby the assessing officer has decided to proceed with the reassessment, and the satisfaction of the officer cannot be supplemented by revenue through subsequent explanation or affidavit. The validity of the action under section 147 should therefore be considered objectively from reasons disclosed in the order itself and not with any supplementary explanation. So, my lord, this High Court has held that it is only the regions those have been recorded have to be read as those have been recorded, and these cannot be supplemented by any other, by way of affidavit or by oral submission. Then, my lord, the third case which I would like to place before your lordship is our own High Court. George Williamson is serial number 4 of the compilation. Page number 24, 26 and 27.
Yeah.
Para 24, page 24, para 16. From the aforesaid decisions of the High Court, highest court of the land, the propositions of law under section 147, 148 are settled. Am I with your lordship?
Yes, yes,
Page 24, para 16.
yes.
Are settled, which are that to proceed under section 147 of the Act, the income tax officer must have reason to believe that income chargeable to tax has been under-assessed, and that in the cases of assessment proceedings initiated after 4 years from the end of the relevant assessment year, he has reason to believe that such under-assessment has occurred by reason of either omission or failure on the part of the assessee to make a return of his income, or omission or failure on its part of the assessee to disclose fully and truly all material facts necessary for his assessment for the relevant assessment year. And these conditions are sine qua non for exercise of jurisdiction by the authority for issue of notice for reassessment. The reasons so given by the assessing authority for initiating proceedings for reassessment, exercising power under section 147 and 148 are justiciable. The court has jurisdiction and authority to satisfy whether in fact the assessing authority had reason to believe, taking into consideration whether the reason so given has a rational connection or relevance for formation of that belief. The rational connection postulated in these sections must have a direct nexus or link, live link with the material coming to the notice of the assessing authority and formation of his belief regarding escaped income. The adequacy and or sufficiency of the reason given is not within the scrutiny of this court. Once the court finds that the nexus between the reason and the belief arrived, once the court finds that there is nexus between the reasons and the belief arrived by the assessing authority, then, my lord, I'll come at page 26, para 19, my lord. In the present case, the assessing authority has not mentioned as to whether, except the letter written by the Commissioner of Income Tax, West Bengal, dated so and so, which was communicated to the Commissioner of Income Tax, Guwahati, he had any other material before him that the alleged payments were in fact not made, and the amount paid in checks were returned back in case after routing it through 4 or 5 bank accounts. He has not mentioned as to when and by what transaction specific amount which have been paid by checks have been returned back in cash. There is no mention of any dates on which the bank transactions between the 4 parties named in the affidavit and the assessee took place, not even the names of the bank allegedly involved. We also fail to understand when the said B.S. Katria has no business transactions with either the assessee or the 4 parties named above, how can he say that the entries in the books of account about the transactions were made and amount was paid in checks merely to accommodate the assessee, and the amount paid in the checks were ultimately returned in case after routing it to the live bank account? So this shows, my lord, the statement of a third party only cannot form basis of a reason to believe. Now here in this case, that Narendra Kumar Jain, we don't know what he has said, whether he has taken our name. When the said Sri B.S. Kathuria has no business transaction with the 4 parties, it is difficult to comprehend how he could know about the transactions which took place between those parties. In the absence of any material before the assessing officer authority, that the amounts which have been paid to checks, the 4 parties have been returned back in case, we find it difficult to understand how the assessing authority could reach the conclusion that the transactions were bogus and the amount paid in checks was returned back to case transaction. There was absolutely no evidence. In the absence of specific material before the assessing authority as to the transactions which have taken place between the assessee and the 4 parties named above, and any material or record to prima facie satisfy that the assessing authority that the amount paid by checks were ultimately returned in case after routing it through 4 or 5 bank accounts. There does not appear to be
any of these matters was any affidavit filed by the respondent.
affidavit was filed.
Are there any materials disclosed as to?
No, they could not disclose any material, my lord. This is what has been pointed out by the Honorable Court.
Yes.
Then, my lord, there does not appear to be any link between the facts found and the satisfaction arrived by the assessing authority. The absence of mentioning relevant fact necessary for formation of opinion by the assessing authority in his order before issuing notice is explained when he has admitted in the additional affidavit that he had not made any independent inquiry for arriving at the prima facie conclusion that the income of the assessee had escaped assessment. In the absence of application of mind to the facts alleged to have been found, the decision arrived at the income escape is not maintainable in law. We do not find that the assessing authority had any reason to believe that the income of the assessee has escaped assessment in the assessment proceedings for the relevant assessment year. My lord, in the in our case, in the case before your lordship, the assessing officer has not made any independent inquiry. He has simply said, as per information received. Now what is it? He has to apply his mind. He has to make independent inquiry to come to a conclusion that there was material which shows that my income has escaped assessment. No inquiry has been made by him. This is what has been held in this George Williamson's case, my lord.
Yes.
Then, my lord, there is another case of our High Court, my lord, Assam Company Limited. It's compilation serial number 5.
Yes.
At page 35, 36, your lordship will kindly see.
Yes.
I will
37.
Para 37, my lord.
Yes.
The expression reason to believe came to be considered in a number of decisions. A few may be referred to. Then, my lord, it says that in Sivanath Singh's case, 82 ITR 147, the apex court held as follows. There can be no manner of doubt that the words reason to believe suggests that belief must be that of an honest and reasonable person based upon reasonable ground, and that the income tax officer may act on direct or circumstantial evidence, but not on mere suspicion, gossip, or rumor. The income tax officer would be acting without jurisdiction if the reason for his belief that the conditions are satisfied does not exist or is material or is not material or relevant to the belief required by the section. The court can always examine this aspect, though the declaration or sufficiency of reason or belief cannot be investigated by the court. Now, then, next para 38, my lord. The same view was expressed in ITO versus Lakshmani Mewal Das, as your lordship were mentioning, where it was held that the expression reason to believe did not signify a purely subjective satisfaction on the part of the income tax officer, and that the reasons must be held in good faith. It was open to the court to examine whether the reason for the formation of belief has a rational nature or relevance bearing on the formation of belief. Then, my lord, I will come to para 41.
Yeah.
The litmus test is decipherable from the consistent judicial pronouncement on this facet of the list. Therefore, is the existence, relevance, and rationale of the reason on which the assessing officer proceeds under section 147, and the bearing it has on the process of formation of belief that the income has escaped assessment. If either of these two essential is absent, the proposed action would be expressly unauthorized. Not only the reason has to be one which is relevant and recognized in law, the same has to have a rational and logical link with the belief that there has been an escapement of taxable income. The belief has to have its roots in the reason, and obviously has to be genuine and bona fide and not merely a pretense. The subjective satisfaction metaforming into the belief has to be guided by objectivity based on existing relevant reasons acknowledged and recognized by law. A tangible and bona fide legal necessity to scuttle tax avoidance is the essence of the power, and no roving inquiry on vague hunches and intermediate and impertinent consideration is admissible. That means, my lord, my case cannot be reopened for making of a roving inquiry to fish out some material.
There has to be satisfaction that it requires reopening.
There has to be satisfaction, and
And
here
satisfaction has to be on the material.
that is condition number 1 in this case, my lord. And the second is the proviso, as I placed before you, lordship, that the he has to make a statement that the escapement of income was because of my failure to disclose fully and truly all the material facts.
Yes.
And my lord, page 36, paragraph 44, my lord. The apex court, while dwelling on the scope of the requirement to disclose fully and truly all material facts as comprehended in the proviso to section 147 held in Parasuram Poultry Works, that the duty of the assessee in any case does not extend beyond making true and full disclosure of primary facts, and it is not responsibility to advise the assessing officer with regard to the inference which we should draw therefrom. If such officer draws any inference which appears to be subsequently erroneous, a mere change of opinion would not justify initiation of action for reopening of the assessment.
Yes.
Then para 45, I've already placed before your lordship this Bombay High Court judgment, Hindustan Liver. They have relied on that, my lord. The same view was expressed in Associated Stone Quota Limited. The Bombay High Court on the same issue in Hindustan Liver held that the regions in support of the proposed action under section 148 must necessarily reveal all facts or material that had not been disclosed by the assessee fully and truly for assessment so as to establish the link between the regions and the evidence. It was further held the regions so recorded cannot be supplemented by any affidavit or oral submission or otherwise. The regions were lacking in the material particulars would receive supplementation by the time those are subjected to a court's scrutiny. Then, my lord, at serial number 7 of my compilation, Northern Exim Private Limited. At page 47. I will refer to para 14 at page 47. My lord.
Yes.
uh, 7 or 8 lines from top in para 14, my lord. The regions recorded, am I with you, your lordship? The regions recorded, however, are not so explicit and do not refer to this fact. We are to be guided only by the regions recorded for reassessment and not by the regions or explanation given by the assessing officer at a later stage in respect of the notice of reassessment. This legal proposition is well settled, and if any authority is needed, reference may be made to the following. They have referred to 7 judgment, my lord. Then the paragraph after that, my lord. The ratio laid down in all these cases is that, having regard to the entire scheme and purpose of the act, the validity of the assumption of jurisdiction under section 147 can be tested only with reference to the regions recorded under section 148(2) of the act, and the assessing officer is not authorized
Yes.
to refer to any other region, even if it can be otherwise inferred and or gathered from the records. That means, my lord, if when they produce the record, if something else is found, as per this honorable court's judgment, it cannot be referred to.
You cannot
He-
supplement it later.
He is confined to the recorded regions to support the assumption of jurisdiction.
Yes.
He cannot record only some of the regions and keep others up to his sleeves to be disclosed before the court if his action is ever challenged. That he cannot do. My lord. Then, my lord, on this proposition, I will refer one more judgment at serial number 6 of my compilation, part 1. That is Madanani Engineering at page 39. The judgment is at page 37 to 40, at particular page 39 to 40, para 6.
Yes.
We, para 6, my lord, at page 39. We may also point out that though this, it was contended in the writ petition that the ITO would have no reason to believe that any part of the income of the respondent had escaped assessment by reason of its failure to make full and disclosure of material fact. The income tax officer did not disclose in his affidavit any material on the basis of which it could be said that he had come to requisite belief. All that the income tax officer stated in his affidavit was that he discovered that the transactions of loan, scrutiny of hundis were not genuine, and that the credits that the credits against the names of certain persons who were alleged to have advanced loan were bogus. The income tax officer merely stated his belief, but did not set out any material on the basis of which he had arrived such belief, so that the court could decide for itself whether there was any material on the basis of which the income tax officer could reasonably entertain the belief. We are therefore not at all satisfied on the affidavit of the ITO had reason to believe that a part of income of the respondent has escaped assessment by reason of its failure to make a full and true disclosure. In this case, my lord, the reason to believe was furnished only by way of affidavit. Then, my lord, my second proposition is that the first proviso to section 147, the failure of the assessee that he failed to disclose fully and truly all material facts necessary for his assessment for that assessment year has to be stated in the reasons recorded by him. Now, some of the cases I have already referred in my first proposition. I will not repeat those cases, but my lord, first case which I want to refer, my lord, is Cedric D'Souza Paria versus DCIT Bombay High Court, serial number 8 of my compilation, part 1. Page 49 to 52. Particular page 51, my lord. Para 8. Right, my lord. On the aspect of reopening of assessment through various judicial pronouncement, certain basic parameters stand firmly established. Section 147 of the Act empowers the AO if he has reason to believe that any income chargeable to tax assessment to reassess the income. Section 147, however, contains a proviso that no action under Section 147 will be taken after a period of expiry of 4 years from the end of the relevant assessment year, unless the assessee had failed to disclose fully and truly all material facts necessary for his assessment of that assessment year. The conditions specified in Section 147 are jurisdictional requirements, and unless they are fulfilled, no proceedings under this section can be taken. It is open for the assessee to challenge the initiation of reassessment proceedings if the assessee is able to show that the jurisdictional requirements are not met. The assessing officer must disclose reasons why reassessment proceedings are being taken out. Further, the assessing officer is not permitted to improve upon the reasons so furnished to the assessee. That means he has to confine only to the reasons those have been recorded. If the assessment proceedings are to be initiated after 4 years on the ground that the assessee failed to make full and true disclosure for all necessary facts, then the assessing officer must state so in the reasons and action must be founded on such reasons. Not only he has to mention in the reasons recorded, my lord, his action has to be founded only on those reasons. Then, my lord, at page 52, para 11, my lord. Six lines from the top. Para 11, my lord. Page 52.
Yeah.
There is no clear statement in the region as to which material the petitioner failed to disclose. On the department's own showing, in view of the subsequent events, that is the appeal of Mr. So-and-so, the reopening of the assessment was necessary. Even in the order, there is no reference to the argument of the petitioner that he had not failed to disclose the fully and truly all material facts. It is not enough that the reason supplied. There is one line to the effect that due to failure on the part of the assessee to disclose fully and truly all material facts necessary for his assessment for the relevant assessment year. This is just a copying and incorporating the language of the section to assume the jurisdiction. Such mere lip service is not enough. When the respondent number 1 dealt with this explanation, reference to the jurisdictional requirement is found only in para 5, while narrating the fact. In the discussion, there is no reference at all to this aspect. Even though the petitioner, para 12, my lord, even though the petitioner can always pursue the remedy under the Income Tax Act against the assessment as per law laid down by the Apex Court, the petitioner is entitled to approach this court under Article 226 of the Constitution if the action of the authority in reopening the assessment is beyond their jurisdiction. The courts have The courts have equated the condition under Section 147 and 148 of the Act to a jurisdictional requirement.
Yes.
The jurisdictional requirement in the present case, namely the failure of the assessee to fully and truly disclose all material facts, is not established. Furthermore, there are no particulars in the region supplied to the petitioner which alone could be the foundation of the order passed under 148 of that. Then, my lord, second case is of our own High Court, CIT versus Sonitpur Solvex, my lord. Serial number 12 of part 1 of the compilation. At page 82 to 92,
Yes.
my lord, this was the case where the Honorable High Court has dealt with the proviso to section 147. And I will straight away,
Page number?
I will straight away take your lordship to para 11. Page number 87, my lord.
Yes.
No, not 87.
Yes, 87.
No, no.
Para 11.
Yes, my lord. The power of reopening of an assessment under section 147 on the ground that an income chargeable to tax has escaped assessment for a given assessment year, the first proviso to 147 carves out an exception. The exception in the simplest word being that no action shall be taken, that is to say, no assessment shall be reopened by an assessing officer by taking resort to his power under section 147 if a period of 4 years from the end of the relevant assessment year elapsed, unless any income chargeable to tax has, as the proviso to section 147 stipulates, escaped assessment for such assessment year by reason of failure on the part of the SEC to disclose fully and truly all material facts. Then, my lord, then I will come at page 90, my lord, para 28. Para 28. In the case at hand, the transport subsidy.
Yes.
Which had been received by the SSC was duly disclosed by the SSC in the audited account.
This is of the same judgment.
Same page 90, para 28, same judgment.
Same judgment.
Sonitpur Solve.
Yes.
The transport subsidy which had been received by the SSC was duly disclosed by the SSC in the audited accounts and statement submitted by the SSC along with the return of income for the assessment year 97-98. In fact, in the paper book filed before the tribunal contains copies of the SSC's audited balance sheet and the statement submitted along with the return. The balance sheet admittedly contains the details of receipt of transport subsidy.
Yes.
Then in para 29, my lord, certain facts are discussed, and then fourth line from the end of this paragraph. In fact, CIT versus Corporation Bank Limited, 254 ITR 791, it has been pointed out by the Supreme Court that disclosure in the balance sheet amounts to full and true disclosure of material facts necessary for assessment. Then my lord, I come to page 91, para 32.
Yes.
In fact, there is not even a particle of accusation in the reassessment order to show that the escapement of income in the present case was because of omission or failure on the part of the assessee to make a return under section 139 or in response to notice under section 140, subsection 1 of 142 or 148, or to disclose fully and truly all material facts necessary for his assessment or the assessment year. A finding to this effect that there was omission or failure on the part of the assessee to make return under section so and so, or to disclose fully and truly all material facts necessary for his assessment for that assessment year is sine qua non or assumption of jurisdiction by the assessing officer for the reassessment of income, which escaped disclosure. We are fortified in taking this view from the decision of Dulichand Singhania's judgment, Honorable Apex Court. Since the present case did not suffer from non-disclosure or omission to disclose fully truly facts, the assessing officer could not have been held, as was rightly not held by the learned tribunal, to have the jurisdiction to reopen the assessment and make the assessment in the present case. Then, my lord, serial number 14 of the compilation.
Yes.
Penner India at page 97 to 106, my lord. Particular pages 101 and 102. Page 101, last paragraph. The precondition for exercise of power under section 147 in cases where power is exercised within a period of 4 years from the end of relevant assessment year is the belief reasonably entertained by the AO that any income chargeable to tax has escaped assessment. However, when the power is invoked after expiry of a period of 4 years from the end of the assessment year, a further precondition for such exercise is imposed by the proviso. Namely, there has been a failure on the part of the assessee to make a return under section 139 or in response to notice under section 142 or 148, or failure on the part of the assessee to disclose fully and truly all material facts necessary for his assessment for that year. Unless the condition in the proviso is satisfied, the assessing officer does not acquire jurisdiction to initiate any proceeding under section 148 after the expiry of 4 years. Thus, in cases where initiation of proceeding is beyond the period of 4 years from the end of the assessment year, the assessing officer must necessarily record not only his reasonable belief that that the income is escaped assessment, but also default or failure committed by the assessee. Failure to do so would vitiate the notice and entire proceedings. Then para 11, my lord. Whenever a notice is issued by the assessing officer, sorry, my.
Okay.
Para 11, my lord. Whenever a notice is issued by the assessing officer beyond a period of 4 years from the end of the relevant assessment year, such notice being issued without recording the reasons for his belief that the income escaped assessment, it cannot be presumed in law that there is also a failure on the part of the assessee to file the returns referred to in the proviso or failure to fully and truly disclose the material fact. The reasons referred to in the main paragraph 147 would, in cases where proviso is attracted, include the reasons referred to in proviso, and it is necessary for the assessing officer to record that any one or all of the circumstances referred to in the proviso existed before issue of the notice under section 147. That means what this court has held, my lord, that merely issuing notice under section 148 is not suffice, my lord. It cannot be presumed. It cannot be presumed that there was a failure on the part of assessee to disclose fully and truly all material facts.
This is in respect of where the notices are issued under the proviso.
Proviso, yes.
So proviso is beyond 4 years.
Proviso is beyond.
So is it to say that if it is within 4 years, hypothetically, if it is under the main section, then is satisfaction that there was a escapement of income is sufficient to issue a notice?
Yes,
But if it is under the proviso, then this escapement attributable to the SSE must be
his failure, my lord, his failure to disclose fully. And this has to be, this has to find place in the reasons recorded. That so and so thing, so and so material, so and so income, as the SSE has failed to disclose. Then, my lord, serial number 15.
yes.
Haryana acrylic manufacturing case. It pays particular page 117 and 18.
So the failure, the satisfaction of the officer that his escapement was because of the failure of the SSE to disclose.
Yes.
That is, I think, specifically it is referred in this serial number 14 judgment, Fenner India.
Yes, my lord. 14 Fenner India, it is referred. In almost all the judgments, it's referred, my lord. Haryana acrylic, which I am now placing before your lordship, is
Yes.
particular page 117.
Yes.
I'll come to para 18. Viewed in the slide, the proviso to section 147 carves out an exception from the main provision of provisions of 147. If a case were to fall within the proviso, whether or not it was covered under the main provision of 147 would not be material. Once the exception carved out by the proviso come into play, the case would fall outside the ambit of 147. Then para 20, my lord, is 117 last. In the reasons supplied to the petitioner, there is no whisper what to speak of allegation that the petitioner had failed to disclose fully and truly all material facts necessary for assessment And that because of this failure, there has been an escapement of income. Merely having a reason to believe that the income had escaped assessment is not sufficient to reopen assessments beyond the 4 years indicated above.
Are the reasons described here? I think para 4.
Para 4. Para 4 of this judgment. My
111, I think, page 111.
No. The Assistant Commissioner of Income Tax supplied the regions for initiating the proceeding under section 148. The regions which were supplied were as under. Regions for initiating the proceedings under section 148. Return of income, this case was filed with now declaring income, nil income. Assessment under section 143.3 was completed at nil. It has come to the notice that the assessee company has taken accommodation entries from one Mr. Sanjay Rastogi, white check number so and so amounting to during the relevant assessment year. I have reason to believe that the income to the extent of 5 lakhs has escaped assessment. As such, after obtaining approval from to reopen the case under section 148, the notice is issued to the assessee. There is no whisper that there was a failure on the part of the assessment. Yes, Mr. Lengner. The assessment, the judgment in the case of Apex Court judgment in the case of C8 Limited, my lord, it pays 122 of my compilation.
Yes.
We have heard Mr. So-and-so. It is not in dispute that the assessment was sought to be reopened beyond 4 years. Therefore, all the conditions under section 148 for reopening of the assessment beyond 4 years are required to be satisfied. Having gone through the regions recorded for reopening, we are of the opinion that the conditions precedent for reopening of assessment beyond 4 years are not satisfied. The reassessment was on change of opinion. There are no allegations of suppression of material fact. Under the circumstances, no error has been committed by the High Court in setting aside the reopening notice. Yeah.
Yeah.
My lord, my third proposition is that regions are required to be read as these are recorded. I will not repeat those judgments which I have already placed before your lordships, which lay down the same thing. The judgment say that no substitution, deletion or addition are permissible. Now, the judgment say that this is a settled proposition that in the event of challenge to the jurisdiction to issue of notice under section 148 on the basis of reasons recorded by the assessing officer.
You are reading from page?
No, I am just
Oh.
mentioning what is laid down in these judgments. Judgments I've already, most of the judgments I've already placed before your lordship.
Yes.
The regions are required to be read as these were recorded by the assessing officer. No substitution or deletion is permissible. No addition can be made to those reasons no inference can be allowed to be drawn based on the reasons which are not recorded. And my lord,
Yes.
as far as the reasons are concerned, my lord, your lordships have referred the case of Lakshmani Mewal Das. There it has been held that even the court cannot substitute its own opinion for that of the income tax officer. It's not yet fair. My lord, I may read certain paragraphs, page number 81 from Lakshmani Mewal Das case. At page 81 of my compilation.
Yes.
I will read from the third paragraph, as stated earlier. The reasons for formation of belief must have a rational connection with or relevant bearing on the formation of the belief. Rational connection postulates that there must be a direct nexus or live link between the material coming to the notice of the income tax officer and formation of his belief that there has been escapement of income of the assessee from the assessment in the particular year because of his failure to disclose fully and truly on all material facts. It is no doubt true that the court cannot go into sufficiency or adequacy of the material and substitute its own opinion for that of the income tax officer.
Yes.
On the point as to whether action should be initiated for reopening of assessment. At the same time, we have to bear in mind, it is not any and every material, howsoever vague and indefinite or distant, remote and far-fetched, which would warrant the formation of the belief relating to the escapement of the income.
Yes.
Then, my lord, the last paragraph on page 81. The powers of the income tax officer to reopen assessment, though wide, are not plenary. The words of the statute are reason to believe and not reason to suspect. The reopening of the assessment after a lapse of many years is a serious matter. The Act no doubt contemplates reopening of assessment if grounds exist for believing that the income has escaped assessment. The underlying reason for that is the instances of concealed income or other income escaping assessment in a large number of cases come to the notice of the income tax authorities after the assessment is completed. The provisions of the Act in this case, in this respect, depart from the normal rule that there should be, subject to right of the appeal and revision, finality about the orders made in the judicial and quasi-judicial proceedings. It is therefore essential that before such action is taken, the requirement of the law should be satisfied. the live link or the close nexus which should be there between the material before the income tax officer in the present. uh, uh, Now that thereafter they discussed the facts of the case before them. They held that there was no live link between those cases. Then the fourth proposition I've already covered, my lord. There has to be a live link between the regions recorded and escapement of income. Rational and intelligible nexus between the regions and the belief.
Yes.
Then, my lord, another proposition is that the report of any investigation wing or any other agency or the valuation officer per se is not an information. Supposing, my lord, the investigation wing has sent some information.
It will not
That
amount to what?
it will not amount to, it will per se not amount to information unless
Yes.
the assessing officer himself makes some inquiries to ascertain the truthfulness of the information. And applies his own mind. The said information cannot be said to be a tangible material.
And which judgment are you referring to?
My lord, my lord, the first judgment is Apex Court. Judgment is Dharia Construction. Is serial number 20, serial number 23 of my compilation. At page 153, my lord. You know?
Yes.
This was a civil appeal before the Honorable Apex Court, my lord. Now the order says, having examined the record, we find that in this case, the department sought reopening of assessment based on the opinion given by the district valuation officer. The opinion of the DVO per se is not an information for the purposes of reopening of assessment under section 147.
Any further judgment to elaborate on this?
Yes, my lord. There are other. I'll place before your lordship. In the assessing officer has to apply his mind to the information, if any, collected and must form belief thereon. In the circumstances, there is no merit. Then, my lord, I'll place at serial number 17, Honorable Apex Court, in the case of Chugamal Rajpal. Page 124 to 128. Particular page 127, my lord. 127 from the middle portion. During the year, the SSC has shown to have taken loans from various parties of Calcutta from DI's investigation number so and so forwarded to this office under CIT Bihar, Odisha, letter number so and so. It appears that these persons are name lenders and the transactions are bogus. Hence, the proper investigation regarding this loan is necessary. The names of some of the persons are mentioned, my lord. The next para says, my lord,
You're referring to para?
para 127, last para. In his report,
Yes.
the income tax officer does not set out any reason for coming to the conclusion that it is a fit case to issue notice under section 148. The material that he had before him for issuing notice under section 148 is not mentioned in the report. In his report, he vaguely refers to certain communications received by him from the Commissioner of Income Tax, Bihar and Odisha. He does not mention the facts contained in those communications. All that he says is that from those communications, it appears that these persons are name lenders and the transactions are bogus. He has not even come to a prima facie conclusion that the transactions to which he referred to are not genuine transactions. He appears to have had only a vague feeling that they may be bogus transactions. Such conclusion does not fulfill the requirement of section 151(2). What the provision requires is that he must give reasons for issuing notice under section 148. In other words, he must have some prima facie grounds before him for taking action under section 148. Further, his report mentions, hence proper investigation regarding this loan is necessary. In other words, his conclusion is that it is a case for investigation as to the truth of the alleged transaction. That is not the same thing as saying that there are reasons to issue notice under section 148. Before issuing notice under section 148, the ITO must have either reasons to believe that by reason of omission or failure on the part of the SSC to make a return under section 139 or for any assessment year to the ITO or to disclose fully and truly all material facts necessary for his assessment for that year, income chargeable to tax as escaped assessment for that year, or alternatively, notwithstanding that there has been no omission or failure mentioned above on the part of the SSC, the income tax officer has, in consequence of information in his possession, reason to believe that income chargeable to tax as escaped assessment for any assessment year, unless requirement of clause 1, clause A or B of section 147 are satisfied, the income tax officer has no jurisdiction to issue notice under section 148. From the report submitted by the ITO to the commissioner, it is clear that he could not have had reasons to believe that by reason of the SSC's omission to disclose fully and truly all material facts necessary for his assessment or accounting year in question, income chargeable to tax as escaped assessment. Then, my lord, the last line of this paragraph, the important safeguards provided in section 147 and 151 were lightly treated by the income tax officer as well as the commissioner. Both of them appear to have taken the duty imposed on them under those provisions as of little importance. they have substituted the form for the substance. My lord, there was, except for a letter received from the commissioner of Bihar, that these parties are bogus name lenders. Merely on that basis, he reopened the assessment. And he recorded in the regions that further investigation is required. So Honorable Apex Court held that these are not the regions based on which you can reopen the assessment. Then, my lord,
But how will he make prima facie satisfaction on this material?
my lord, he can conduct inquiries, he can
No. Where is in what manner?
inquiry in an income tax authority.
There is a material coming to the assessing office that these persons have deliberately suppressed or not. So this income, the returns which he has filed, the assessments which he has made require reassessment.
My lord,
Now, in order to satisfy that whether this material has uh, material contains certain ground, in order for the assessing officer to return a finding, at least a prima facie finding, that will require. As you say, he has to make preliminary inquiry. Preliminary inquiry on what?
my lord, supposing he has received some information from some agency, maybe DIT investigation or some other
No,
agency.
like, in the facts of the case.
In this facts of this case, particular case, an assessing officer has got plenty of powers, my lord. He could have issued summons,
What information did you receive? One letter
one letter,
saying
saying that these are, in my particular case, my lord.
Yes.
In my particular case, my lord, he said information has been received. From where it has been received, he doesn't mention. Then he said that I've raised a share capital of 1 crore 51 lakhs. He does not mention the names of the companies, who are the companies from whom I have received the share capital, how much amount I have received, the date on which I have received, the modes through which I have received. It doesn't say anything. He has referred to statement of one Mr. Narendra Kumar. Now, we don't know who is Narendra Kumar, what he has said in his statement, whether he has taken our name or not. They say he is entry provider. We have not taken any entry. There is no evidence. Despite my case being a search case, where all my documents were seized, they have found nothing. They have found no incriminating material, which shows that the money was sent by me, and in turn he has sent me the check. I have paid him commission for taking that accommodation entry. There is nothing. Nothing is on record. Then how we can derive the satisfaction?
In other words, you are saying that besides that small paragraph,
Huh.
there are no material
There, yes,
prima facie come for the court at least
yes, my lord.
to come to a finding.
Yes.
How, what is the direct link or nexus between that information and the material which is received requiring reopening of the account? That's your,
That is my, and I place before your lordship the assessment order, which shows that he has examined everything, including the seized material. Not only he himself has examined, his higher authority has given approval for that assessment.
so there was disclosure.
There was total disclosure. The share capital was disclosed in my balance sheet.
So your case falls under the proviso. Is it not under the proviso?
Proviso also, my lord, proviso also. But the first condition for having reason to believe is also not satisfied.
No. That is there, but your case is a case under the proviso.
Under the proviso.
So therefore, it is not sufficient to have some escapement of income.
Yes,
There must be a satisfaction that it was at the behest of the SSC. Because of the fault of the SSC or non-disclosure,
right.
there was an escapement of income.
Right.
And which according to you is belied by the returns which have been filed
Hmm.
after the search and seizure, also approved by the higher authority.
Higher authority, everything has been examined. They have not found any incriminating material about this transaction. Then, my lord,
We can come back in the second half if
Right.
there is something more to be heard.
Eviction matter, lordship, in the morning gave permission, very short matter. Has the registry has my lord published a list, unlisted motion.
Who is your counterpart?
Government.
Is it okay if we take it up at 2 or
At two, my lord.
at 2?
At two, my lord, and just thereafter he will take, continue, my lord. Take 5 minutes. short matter.
You may inform the respondent.
Yes, we should. They were there here. Obliged.
39.
39.
We can't fix you a date now. We'll go after vacation. We'll go after vacation. Item 28,
39.
39.
Hearing.
Hearing matter.
2015.
Be taken up after vacation on a date to be fixed by the registry.
May pay you. My lord, it is under peculiar circumstance. I am filing this, coming before your lordship, my lord. I am a bank at Sonari. My lord, from a rented building, my lord, the bank was running for last about 15 years. 12 years. This is the only bank covering a huge locality, my lord. My lord, then what happened? There was a land acquisition process started by the government for extending and widening of a road, my lord. That's fine. That is, my lord, for a public purpose. But my lord, landlord didn't inform us, even after receiving the, my lord, various stages, and even after receiving compensation. So we discovered a copy, my lord, which is at Annexure 6 at page 53.
Yes.
It is addressed to the landlord. My lord, she is the landlord. It is in Assamese. I have given English translation also. Also, page 53. আপোনাক জনোৱা হয় যে সোণাৰী ৰাজচক্ৰৰ অন্তৰ্গত অসমমালাৰ অধীনত সোণাৰী টাউনৰ পৰা লংপটীয়া গাঁৱলৈকে নাহৰ আলি সম্প্ৰসাৰণ হওক, যিহেতু ইতিমধ্যে নিৰ্ধাৰিত ক্ষতিপূৰণ দিছে, গতিকে অহা 5 দিনৰ ভিতৰত ঘৰ খালী কৰিব দিয়ে। Now we came to know from this was of April 2024, last April. Then, my lord, we represented, being the occupier, to the, not, my lord, opposing the land acquisition, praying for some reasonable time so that we can shift to a new premise, my lord. We immediately, my lord, represented, and we have, my lord, submitted this annexure, page 54 annexure representation. Now, page 59, the notice has been given to me this time. This was 6/6, only last week. Page 59. Reference to above, lordship kindly mark, earlier notice was to the landlady, this time they have given to us. So there were some procedural irregularities. I am not on that. We are not opposed to the, my lord, basic purpose of widening the road. I would like to inform you that the Damas complex where your bank is functioning now has already been acquired for widening of road. We are going to demolish the building at the earliest possible time. So you are again requested. Now, my lord, we have arranged for an alternative premise.
Yes.
So unlike any other establishment, a bank, my lord, cannot be suddenly shifted, my lord. There are certain protocols. Let me come to paragraph 8, page 10, my lord. Below, my lord, your lordship. Paragraph 10. We have around, paragraph 8, page 10 below, we have around 2,000 saving accounts, 370 current accounts, 60 number of gold loans, including various loan accounts, 160 number of salary accounts. And apart from, my lord, there are lockers. Further, next page. Further, as per the internal policy and regulation of the bank, there are guidelines of it must give at least 60 days time to its customers to take back their valuables from their lockers and other gold items against which they have availed gold loans. Petitioner bank will suffer, my lord. So, my lord, there are some customers, there are public interest is also there, my lord. We are not saying that we are not shifting. But being a bank, my lord, and moreover, earlier notice was given to the landlady. It came all of a sudden, my lord, the last notice, 6/6. That you remove, otherwise we will bulldoze. So basically, my lord, I need some time. I am not opposed to the land acquisition, my lord, in principle. I'm not even, I am bothered about compensation. I am not entitled to being a tenant. But being a bank,
Yes,
Lordship, this is Annex 3, page 47 now.
40.
7. Paragraph 4. In light of the above, requesting your good office 2 points. Firstly, to allow us to continue our operation for an additional period of 1 year. That was within Lordship 30 March 23, Lordship. Already they have get more than 1 year, Lordship.
yes, that was given.
Lordship, that is,
But demolition was not imminent at
Lordship.
that time. Demolition was not imminent.
No, they have got all enough time.
Subject indicates it is demolition.
Demolition was not imminent at that time. We knew that the project was going on. We also represented we are bank. But then thereafter, after this letter from us, we charged desperately for an alternate premise and we got it. Now, unlike other establishment, we have to construct the lockers and all these things, my lord. So we need some more time. Lordship may take it that way. And so far as the project is concerned, my lord, at a stretch of length, my lord, some buildings have been, my lord, removed, some structures sliced, removed. This process is still going on. Then will come the process of construction of the road and then rolling and blacktopping, etc. That has not yet started. My lord.
You get the instruction. Who's for the
PWD will know better.
PWD department? You will have to get instruction.
Visual.
Get informed. You serve copies on PDF.
We have informed.
And Mr. Borden. Hearing for the petitioner. Petitioner is the bank.
Last notice, my lord.
Registered as the company like 1986 different officers. And the petitioner presently and has a branch. He is registered officer branch at Sonari. Ojotiniali, Dora, Sonari town, district Toraido. Mr. Boy,
Lordship.
any instructions here?
No, my lord, it just come up for the first time, my lord.
You get
But I can have the instruction tomorrow itself, my lord.
Tomorrow.
No point giving it pending. So ultimately, they've got the money.
No. We are not opposing land acquisition. We are in principle, we are not.
They are not the
Landlord.
landlord.
Landowner.
They are the tenants.
Then it's, my lord, the bank.
They are asking for some time to relocate.
That, my lord, I will have the instruction.
We have arranged for alternate premise, my lord.
Got instruction.
We'll keep it on Wednesday.
No.
19th.
My lord, anytime the
18th.
bulldozer comes.
18th. Challenge the seeking a direction. Seeking a direction to consider their representation. Dated 25/4/2024. Which Where is the representation?
My lord, first representation was page 54. At that time, my lord, eviction was not imminent. Now we are basically agreed by, now my lord, the danger comes from page 59.
Yeah.
That is the order, my lord.
The petitioner, bank. The tenant and operates a branch, the bank.
We have already
under-
acquired alternate premise
under,
to see, yeah,
premises
round the clock works are going on.
premises of the respondent number 5. Subsequently, petitioner has been informed that for the purposes of widening the road which runs in front of the property, land has been acquired by the PWD department, and compensation to that effect has already been paid to the land. However, all these facts, according to the council, not brought to the credit bank. They submitted that at this stage, it is submitted that the bank at present has 1,000 numbers of saving account.
And locals.
The bank at present for the is the imminent demolition of the complex. See of the notice dated 6/6/2024 issued by the executive engineer Peter RD right over district editorial whereby branch manager of the state bank was informed that the building has been acquired by the PWD for widening of the road of Harali, and they will demolish the building at the earliest possible time. The bank was asked to vacate prior to demolition. Apprehending imminent demolition, the bank has approached this court seeking a direction.
Lordship may also have observed that we have already arranged for alternative premise.
Represented and in the meantime, since an alternative arrangement has already been made, they pray for some time to complete the process of demolition. Newly acquired, newly tenanted. Submitted that view of the huge number of customer base,
And locals.
as well as the valuables of the customers stored in the lockers of the bank. Interest of the within public interest that other timely done. Bank has prayed for make suitable alternative arrangement and complete the process of relocation. The same alternative. Mr. N goes on, the examiner advocate submits that the notice for demolition was issued to the was issued
Page 59.
It's 47.
Earlier.
year back, and to which the bank has replied by their communication dated 3/2020.
Yes.
Therefore, since more than a year has elapsed since it was brought to the notice of the bank that the premises is required for widening of the bank of the date. Mr. P. Gogoi, Standing Council PW, submits that we like to obtain the instructions.
We both will have to, because the communications are made to the circle officer too.
Submits Mr. P. Gogoi along with Mr. N.
But one thing, my lord, regarding the inspection part, actually what will have to seek inspection? The documents are very clear. For last 1 year, they are enjoying
They
it.
are only asking for some time. So you can seek instructions to this effect, that what is the maximum time you can grant, so that they can.
Whether they've got the legal right to claim for that time now at this stage, for last 1 year they've been enjoying it. So I can
Therefore-
have the instructions. I
Therefore,
can-
you get your instructions, then
Not my lord.
you'll have to decide this matter.
Not that they will, whenever they will come, they will get the relief anytime, in all cases.
You can decide and fix a time within which they may vacate the premises.
My lord, my lord.
Let the matter be listed again on 18th
18, let it be on 18, I will have to.
18th June.
My lord, can it be on 19, my lord?
No, let it be on 18th,
18, lord.
unless you are out of town. Let it be on 18th. Let them get their instructions. Because, extra copies be furnished to the Learned Standing Council. And the petitioner advocate on record will also take steps by Dusky on the respondent number 5 within the course and file an affidavit of compliance for the next day. Accordingly, let the matter be listed again on 19th, enabling the respondent, sorry, 18th,
18th, Lord.
enabling the respondent councils with their instructions in the price report. Meanwhile, the PWD department did not proceed for demolition of this building till the next day.
All right. I think they two and 2.5 months, my lord, everything will be. Because we are,
Let us see what instructions we get.
we have to issue notice to all locker holders, my lord. That is the.
But it prima facie appears you were aware about a year back. What were you doing?
We are not finding. We are not finding alternative places, but during this period, somehow it was very difficult. We got one premise and now, my lord, round the clock work is going on. That I have already stated.
You also get your instructions what time you
You
require.
required.
Yes, ma'am. It is not that we are refusing to shift.
One liberty may be given so that our officers may visit their premises tomorrow. At least they can examine whether actually they are doing their work or not. That liberty may be given.
Alternate premise.
At least tomorrow they will
Yes,
come.
yes, yes,
You
yes.
are at liberty. We
Well,
just don't
No,
demolish.
that is a good
No,
suggestion.
not demolish, but at least what they are doing, my lord,
Yes,
to
just don't
relocate
demolish.
it to a new place.
My lord, that is a good suggestion.
Just don't
We have
demolish
bona fide, my lord, doing
is
all the
bona
works,
fideness, yeah.
alternate premise.
or take any steps to threaten them out of the premise.
My
Just don't do that.
Lord.
You can visit and find out.
Lord,
And
that,
then
that I will
come back on 18th.
mind.
All right.
My lord. You know, the last proposition which I made, that the report of investigation linked or the valuation officer per se is no information. Application, independent application of mine and inquiry is needed, my lord, is required to verify the correctness or relevance or otherwise of the information that has been received by them. My lord, on this proposition, I would like to place one or two more cases. And then, my lord, I'll go to the next proposition. RML video. Serial number 18 of my compilation, my lord. RMG polyvinyl is page 129 to 132. At particular page 132.
Yes.
Para 13 at page 132, para 13, my lord.
Yes.
As in the above case, even in the present case, the court is unable to discern any link between the tangible material and the formation of regions to believe that the income has escaped assessment. In the present case, too, the information received from investigation wing cannot be said to be tangible material per se without a further inquiry being undertaken by the assessing officer. In the present case, the AO deprived himself of that opportunity by proceeding on the erroneous premise that the assessee had not filed a return of income, when in fact it had. Then, my lord, then, my lord, at serial number 4 of the compilation, George Williamson, Assam. Particular page number. Particular para 19 at page 26, my lord. My lord, I have already placed this para.
Yes, you already referred.
My lord. Then, my lord, at serial number 2 of the compilation, Commissioner of Income Tax versus Atul Jain at page 7 and 8. My lord. Second paragraph, my lord, is page 7. From the decision of the Supreme Court, it is clear that a mere statement of facts in the form of a report is not a substitute for reasons that are required to be recorded before issuing a notice under section 148 of the Act. The Supreme Court also noted that substance cannot be substituted by form. And it is in that context, the Supreme Court expressed the view that by merely saying yes, the commissioner also did not fulfill the duty cast upon him. Then, my lord, please come to the last part of page 7. After a foundation based on information is set up, there must still be some regions which warrant the holding of a belief so as to necessitate the issuance of a notice under section 148. Looked at in the light of the decisions placed before us and the law laid down therein, it is necessary to appreciate that the information available with the assessing officer in the present case, the only information that the assessee had taken bogus entry of capital gains by paying case along with some premium for taking a check for that amount. The information does not indicate the source of the capital gains, which in this case are shares. We do not know which shares have been transacted and with whom has the transaction taken place. There are absolutely no details available, and the information supplied is extremely scanty and vague. Insofar as the basis for regions is concerned, even this is absent. The assessing officer did not verify the correctness of the information received by him, but merely accepted the truth of the vague information in a mechanical manner. The assessing officer has not even recorded his satisfaction about the correctness or otherwise of the information, or his satisfaction that a case has been made out, or issuing a notice under section 148 of the Act. Read in this light, what has been recorded by the assessing officer as his reasons to believe is nothing more than a report given to him by the Commissioner of Income Tax, as held by the Supreme Court in Chugamal Rajpal, the case which I've already placed before your Lordship. The submission of a report is not the same as recording of the reasons to believe for issuing notice. The assessing officer has clearly substituted form for substance, and therefore the action of the respondent falls foul of the law laid down by the Supreme Court in Chugamal Rajpal, which is clearly applicable to the facts of these appeals. So, my lord, serial number 36 of my compilation in part 2, my lord. Compilation page 279. Two 279 and 280, my para 9. The root of the matter is whether there were facts. This is this honorable court's judgment, my lord. The root of the matter is whether there were facts from which it could be believed that there was failure or omission to disclose fully and truly material facts for the assessment resulting in seepage of tax from assessment for the year in question. Under the law, the assessee owes a duty to disclose fully and truly all primary facts for the assessment. Calcutta Discount Company Limited, followed by Supreme Court in the cases of S. Narayanappa and Lakmani Mewal Das. Calcutta Discount Company's case, my lord, it was a constitution bench judgment. Then, my lord, para 10. Last 5 lines, my lord. The company submitted the audited profit and loss account and balance sheet particulars. The unadjusted amount received from the UFFUO was cited at rupees 31,58,700 under the head current liability. As advance received from FUO, the order sheet dated 30th March, whereby the assessing officer decided to issue notice under section 148 on formation of opinion under section 147A also recounted the above facts. The assessing officer in the said order sheet also mentioned that the assessee was asked to show cause as per letter dated so and so as to why proceedings under section 148 would not be initiated for failure to disclose full quantity and the value of stock mentioned in the order. The learned single judge has addressed his mind to the necessary facts and found that there was no failure on the part of the assessee to disclose all material necessary for making assessment. The amount was disclosed in the balance sheet. And at serial number 35 of my compilation, my lord. CIT versus Corporation Bank. Is apex code, particular page 272, 273, my lord. Page 273. Para 2, my lord. Incidentally, it would be noted that the SAC has disclosed this sum of rupees 58,485 in the balance sheet as unrealized amount of interest along with the return filed by it, and the ITO has accepted the return as a matter of fact, had excluded that amount in the assessment order completed on so and so. Then para 6, my lord. Turning attention to the first question as regards provisions of section 147A, be it noted that as the facts depict, there is no failure on the part of the SEC in furnishing the particulars pertaining to the above facts, noted sum as not recoverable from the relevant for the relevant accounting year, and the statements filed along with the original return disclosed the full details of the aforesaid amount. There is therefore no failure on the part of the SEC to disclose fully and truly the material facts necessary for the assessment for the respective years, and as such 147 has no manner of application and is not attracted in the facts of the matter under consideration. The High Court on consideration of the facts came to the conclusion that the tribunal was justified in coming to the said finding, and we also record our concurrence therewith. Then, my lord, the legal proposition is that in the name of exercising power under section 148, 47, the assessing officer cannot institute a roving inquiry with the object of fishing out some material.
You're reading.
No, I am making a legal proposition.
Okay.
The case law I will now rely on it. It is Guwahati High Court, my lord, at serial number 5 of part 1 of my compilation.
1 minute.
Serial number 5, pages 29 to 36,
Just a minute.
my lord. Para 41.
Yes, what is your submission?
My lord, My submission is that in the name of exercising power under section 147, the assessing officer cannot institute a roving inquiry with the object of fishing out some material. Now, at page 35 of my compilation, part 1, my lord, in Assam Company's case, para 41, my lord, at page 35.
It's serial number 5.
Serial number 5. At page 35,
Paragraph.
paragraph 41, my lord.
Yes.
Para 41, the litmus test,
You already referred to.
I only want to rely on the last line of this paragraph. And no roving inquiry or on vague hunches or intermediate and impertinent consideration is envisaged. That means no roving inquiry is permitted. Then, my lord, the last proposition which I would like to make is that the assessee's duty is to make disclosure of only the primary facts. It is not for him to tell the assessing officer as to what factual or legal inferences he should draw from it.
Yes.
My lord, on this proposition, I have already placed Sonitpur Solvex case. Honorable Guwahati, our own High Court, my lord. I have from Pottery. Yes, Paruguru. Then, my lord, another judgment is at serial number 34 of my compilation at part 2. Parasuram Pottery Works, my lord. Page 264 to 271. Page 270, my lord. My lord, at page 269, last 4 lines. Last 5 lines. The duty of the assessee in any case does not extend beyond making a true and full disclosure of primary facts. Once he has done that, his duty ends. It is for the income tax officer to draw the correct inference from the primary fact. It is no responsibility of the assessee to advise the income tax officer with regard to the inference which he should draw from the primary fact. If an income tax officer draws an inference which appears subsequently to be erroneous, mere change of opinion with regard to that inference would not justify initiation of action for reopening of the assessment. This view was taken in Lakhmani Mewal Das case. And then at page 270, my lord, the words omission or failure to disclose fully and truly all material facts necessary for the assessment for that year postulate a duty on the assessee to disclose fully and truly all material facts necessary for his assessment. What facts are material and necessary for the assessment will differ from case to case. In every assessment proceeding, assessing authority will, for the purpose of computing or determining the proper tax due from the assessee.
Mr. Goenka, just a minute. Yes.
My lord, I was on page 270.
Yes.
What facts are material and necessary for assessment will differ from case to case. In every assessment proceeding, the assessing authority will, for the purpose of computing or determining the proper tax due from an assessee, require to know all the facts which help him coming to the correct conclusion. From the primary facts in his possession, whether on disclosure by the assessee or discovered by him on the basis of fact disclosed or otherwise, the assessing authority has to draw inference as regards certain other facts and ultimately from the primary facts and the further facts inferred from them, the authority has to draw proper legal inferences and ascertain on a correct interpretation of taxing enactment the proper tax leviable. See Calcutta Discount Company versus ITO as further observed in that case. It was observed in Calcutta Discount Company's case. Does the duty, however, extend beyond the full and truthful disclosure of all primary facts? In our opinion, the answer to this question must be in the negative. Once all the primary facts are before the assessing authority, he requires no further assistance by way of a disclosure. It is for him to decide what inference of facts can be reasonably drawn and what legal inference have ultimately to be drawn. It is not for somebody else, far less the assessee, to tell the assessing authority without what inferences, whether of facts or law, should be drawn. Indeed, when it is remembered that the people often differ as regards what inferences should be drawn from a given fact, it will be meaningless to demand that the assessee must disclose what inference, whether of facts or law, he should draw from the primary facts. This is the principle that has been decided, law that has been decided by the Honorable Apex Court Constitution Bench in Calcutta Discount Company's case.
Yes.
Then, my lord, this page 271. Page 271, last category. It has been said that taxes are the price that we pay for civilization. If so, it is essential that those who are entrusted with the task of calculating and realizing that price should familiarize themselves with the relevant provisions and become well versed with the law on the subject. Any remissness on their part can only be at the cost of national exchequer and must necessarily result in loss of revenue. At the same time, we have to bear in mind that the policy of law is that there must be a point of finality in all legal proceedings. That stale issue should not be reactivated beyond a particular stage. And that lapse of time must induce repose in and set at rest judicial and quasi-judicial controversies, as it must in other spheres of human activity.
Yes.
So far as the income tax assessment orders are concerned, they cannot be reopened on the score of income escaping the assessment under section 147 after the expiry of 4 years from the end of the assessment year, unless there be omission or failure on the part of the assessee to disclose fully and truly all material facts necessary for the assessment. As already mentioned, this cannot be said to be in the present case. The appeal is consequently allowed. The judgment of High Court is set aside. My lord, these are the legal propositions which I wanted to rely. My lord, now after having received the reasons recorded from the assessing officer, we filed our objections on the reasons recorded. And our objections filed is annexure 16 at page 109.
Yes.
I'll read from page 110, my lord. In this respect, we respectfully submit as follows. The reopening of assessment for the assessment year purportedly under 147 by issue of the aforesaid notice under section 148 dated 31st March on the aforesaid purported region is not countenanced in law as the condition precedent to exercise the jurisdiction under said provisions are not fulfilled in the instant case. At first, in the aforesaid region, you have made a statement referring to some information that we raised share capital of 1,51 lakhs by allotment of shares with allotment at face value of ₹10 and premium of 90. You have not stated the detail, nature and source of the information. However, the information were already in the assessment records. As we were assessed for the assessment year 2010-11 under section 143(3) oblique 153C on 31st March 2015, subsequent to a search and seizure under section 132 and survey operations in the case related to concern. All these facts were available in the reports and those do not constitute any tangible material to form any reason to believe that any income has escaped. is 111, my lord.
Yeah.
It is a fact on record that the assessment under section 143 has already been made for the relevant assessment year for the year on 31st March 2015. There was no failure on our part to make a return under section 139 or in response to notice under section 142(1) or 148, or to disclose fully and truly all material facts necessary for the assessment for that assessment year. It is also a pertinent fact that the aforesaid assessment was made pursuant to a search and seizure 4 years from the end of the assessment year has expired on 31st March. Therefore, the instant action under section 177 read with 148 is not tenable, being without jurisdiction and liable to be dropped in any view of the matter. Secondly, you have referred again to some information without reference to its detail, nature and source, that most of the LOT companies are paper companies which exist on paper with no genuine business of their own. No details, my lord. It is evident that the information is totally vague and it amounts to allegation only, which of such companies exist only on paper without genuine business of their own is not stated. In the region recorded, there is nothing to show as to how or why those companies, whether paper companies with no genuine business or otherwise, have any live link or nexus with the escapement of assessment of our income for the said year. There is no live link. Thirdly, you have mentioned that as per data prepared by DIT investigation, Kolkata, most of these companies belong to Sri Narendra Kumar Jain, who during the course of survey conducted on ITNA had purportedly sworn under oath that he was an accommodation entry provider who provides bogus accommodation entry, bogus unsecured loan, etc. The statement referring to certain data by another authority are entirely vague in as much as those do not state as to which companies are referred to and how are those connected to escapement of income. Even it is not mentioned how such data has any relevance to alleged escapement of our income from assessment. There is complete absence of any material showing and or establishing any live link between the statements made in the region purportedly recorded under section 148 and any escapement of our income. It is totally devoid of any material required for the purpose of assumption of jurisdiction under section 147, as read with section 148. In fine, the first paragraph of the aforesaid region has no tangible material showing live link with the escapement of our income from the assessment for the assessment year 10-11. There is no application of mind or independent inquiry to verify the correctness, relevance or otherwise of the information purportedly received to bring it on record, records any cause, justification, or in other words, any reason leading to formation of belief within the pale and ambit of section 147. To provide the foundation for assuming jurisdiction under section 147, to issue notice under section 148 after recording the region for the income. The remaining two paragraphs of the regions recorded of the IT Act contain no reason to believe within the meaning of section 147, as those contain your assertion that income to the extent of 1,51 lakhs has escaped assessment for the financial year 9-10, relevant to the assessment year 10-11 in our case, and that it is a fit case for issue of notice under section 148. The last paragraph shows that you had sought approval from the issue of notice. Sorry, ma'am. From the principal CIT in conformity with section 151, and it evidently contains no reason to believe. However, it is not stated on which date the reason was recorded. Approval under section 151 was sought and approval was granted. These being material facts may kindly be communicated to us. On the above basis, we submit that there is nothing in the so-called region recorded to link us with the so-called escapement of income. So in view of the above, it is submitted the precondition for invoking provisions of section 147 not being satisfied or fulfilled in our case. The aforesaid region purportedly recorded under section 142, 48(2) is no reason to believe in the eyes of law. Therefore, the aforesaid notice dated Itna issued under section 148 based on such reason is without jurisdiction. You may therefore be pleased to drop the proceedings initiated under section 147 for the year under reference. We request you to kindly dispose our objections in accordance with the judgment of Honorable Apex Court, GK and Drive Soft India Limited versus ITO 259 ITR 90. This was the objection raised by us. And then page number 114, annexure 17. Is the order of the assessing officer disposing the objections raised by us.
Yes.
My lord, I will read from page
You can come to the last paragraph.
117, my. Findings with reasonings and the conclusion. Now, what the assessing officer says, my lord, the submission of the assessee is considered thoroughly. Page 117. My.
Yes, yes. So these are discussion of the case law
Huh.
in support of their
Yes, ma'am.
finding.
Yes.
The finding is probably the last page,
117,
119,
119.
last paragraph.
Now, my lord, it may, 119, it may also be stated here that as per provisions of section 147, explanation to CA,
No, this is the quotation below that. In the instant case, I think that's the
in the,
finding.
in the instant case, the information has been received from Directorate of Investigation that the company Messrs Mukund Infrastructure has raised capital of rupees 1 crore 51 lakh with face value of rupees 10 and premium 90. Most of the allotee companies for that particular corresponding year with reference to capital of Mukund Infrastructure are paper companies which exist only on paper with no genuine business of their own. Most of the allotee companies belong to well-known entry operator of Calcutta, Narendra Kumar Jain, who had sworn under oath that he is an accommodation entry provider who provides bogus accommodation entries, bogus unsecured loan in lieu of cash commission. Now, while rejecting our objections, my lord, the assessing officer has introduced some fresh facts here. Now, he says, in lieu of cash commission, the lordship will kindly have a look at the reasons recorded. There is nothing like this has been recorded in the region. Now, there is no material of such payment made, cash commission. My lord will kindly come to the reasons recorded. I will once again. Page 108, my lord. Nothing is recorded. That case commission was paid to Narendra Kumar Jain or anybody else. So the assessing officer has tried to change the reasons recorded, my lord. And as I have submitted, when there is a challenge to notice under section 148, the reasons are required to be read as those are recorded. And my lord will kindly see page. We had made a categorical submission at page 111 of our objection. Our contention was that there was no failure on our part to disclose fully and truly all material facts. He has not dealt with this part. He has omitted totally. Even where he has reproduced our submissions, kindly see at page 115. At 115. also.
Yes.
He has, while reproducing the submissions made by us, he has deleted the relevant portion which was mentioned by us at page 111.
Hundred?
111, my lord. We have specifically submitted
Yes.
that there was no failure. He has not dealt with this submission at all. And then, my lord, at page 119, the assessing officer has relied page 119 from the top, my lord. It says, my lord, it may also be stated that as per provisions of section 147, explanation 2CA to section 147 states as follows. Quote, where a return of income has not been furnished by an assessee or a return of income has been furnished by him, and on the basis of information or document received from prescribed income tax authority under subsection 2 of section 133C, it is noticed by the assessing officer that the income of the assessee exceeds the maximum amount not chargeable to tax, or as the case may be, the assessee has understated the income or claimed excessive loss, deduction, allowance or relief in the return, unquote. In the instant case, the information has been received from Directorate of Investigation. Now, Directorate of Investigation is not the prescribed authority under section 133C. He is not the prescribed authority. So therefore, the report sent by him cannot be a report sent under section 133C.
What is the prescription of the section?
Yes, my lord, I'll just take your look. Yep. Section 133C, my lord. My lord, first, may I take your lordship to section 147, explanation 2CA. Then I come to section 133.
Yes.
Now I come to explanation 2 to section 147.
Yes.
For the purpose of this section, the following shall also be deemed to be cases where income chargeable to tax has escaped assessment. Namely, there is A, B, B, A, C, and then CA. Man. He relies upon CA. Where a return of income has not been furnished by the assessee or a return of income has been furnished by him, and on the basis of information or document received from the prescribed income tax authority under subsection 2 of section 133C, it is noticed by the assessing officer that the income of the assessee exceeds the maximum amount not chargeable to tax. Or as the case may be, the assessee has understated the income or has claimed excessive loss, deduction, allowance, or relief in the return. Now, this explanation CA refers to information or document received from the prescribed income tax authority under section 133C subsection 2. Now I come to section 133C.
Yes.
133C, my lord. Power to call for information by prescribed income tax authority. The prescribed income tax authority may, for the purposes of verification of information in its possession relating to any person, issue a notice to such person requiring him on or before the date so specified therein to furnish information or documents verified in the manner specified therein, which may be useful or relevant to any inquiry or proceeding under this act. Subsection 2, my lord. Where any information or document has been received in response to a notice under section notice issued under subsection 1. The prescribed income tax authority may process such information or document and make available the outcome of such processing to the assessing officer. The board may make a scheme for centralized issuance of notice for processing the information of documents and making available to the outcome to the processing to the assessing officer. Now, my lord, here this scheme was notified on 31st January 2019. I'll file a copy of the scheme. And what they claim is that it was sent by the DI investigation, who was a prescribed authority. He was not a prescribed authority
Under that scheme.
under the scheme. Now, I'll place. Now they have made rule 12D of the income tax rules, where they say
Just 1 minute. Yes.
my lord, the framed rule 12D of the income tax rules. The rule is not there, my lord.
Rule है. You're referring to rules?
Rule 12D, my lord.
Well,
12 capital D. 12D, may I read it, my lord? The prescribed income tax authority under section 133C shall be an income tax authority not below the rank of Assistant Commissioner of Income Tax who has been authorized by the Central Board of Direct Taxes.
And the CBDT has come out with this notification.
Yes, my lord, I will place that notice. No, no. My lord, immediately after this scheme was formulated, which I placed before your lordship, this notification was issued by the Central Board of Direct Taxes.
It's for centralized issuance of notice. This particular notification,
Yes, my lord.
30th of January 2019, you have produced.
That was the framing of scheme.
No, no, this is the scheme for centralized verification.
Yes, yes, my lord. Yeah. That is issued for the purpose of section 133 C, my lord.
Now, who's described as the
Prescribed authority.
prescribed authority?
My lord, this, the notification, copy of notification, which I placed before you now,
Right.
dated 13th March 2019. Kindly see para 1.
Okay.
The CBDT directs hereby directs that the Commissioner of Income Tax specified in column 1 of the schedule annexed here to having his headquarters at the place specified in the corresponding entry in column 2 of the said schedule to exercise the concurrent powers in addition to any other authority under the Income Tax Act. For the for the purpose of centralized issuance of notice and for collection and processing of information or documents and making available the outcome of the collection and processing under subsections 1 and 2 of section 133C. So he is the prescribed authority under section 133C 1 and 2. And in the schedule, my lord, at the last of the page, of the first page, at the end of the first page, my lord. Designation of the Income Tax Authority, Commissioner of Income Tax. Commissioner of Income Tax, e-verification, next page. Then headquarter is at Delhi. And his jurisdiction is all cases of persons in respect of all incomes within the limits of all states and union territories of India, with respect to whom there is any information in possession of the Directorate of Income Tax Systems, Central Board of Direct Taxes.
No, for what purpose have you framed the scheme?
I have placed the scheme just to demonstrate, your lordship, that explanation 2CA of section 147, which they have relied upon, stating that any report by the prescribed authority under section 133C2 can also form part of information. It says that it is noticed by the assessing officer. The assessing officer has failed to notice that the person who has sent the so-called report was not a prescribed authority.
No, that is what is not discernible from the notification. It does say who would be a designated authority.
My lord, this notification says para A, I have mentioned para A1.
Para
Para A1,
A1.
A1.
Yes.
It says for the purpose of centralized issuance of notice and for collection and processing of information or documents and making available outcome of the collection and processing under subsections 1 and 2 of section 133C.
This is for calling for information
Yes, ma'am.
by prescribed authority.
Oh.
Here is a case where from a prescribed authority, some information has come to the assessing officer.
No, my lord. The officer who has sent the information, he is not the prescribed authority. This is what I want to submit, my lord. The information that has been sent,
This prescribed authority, there is no specific definition to show who will be a prescribed authority.
my lord, I will.
Now, this notification that you are trying to refer to is only for these ABC purposes.
ABC, I'll read this notification with section 133C,
Yes.
my lord. I'll. Now, 133C1. The prescribed income tax authority may, for the purposes of verification of information in its possession relating to any person, issue a notice to such person requiring him on or before a date to be specified therein to furnish the information or documents verified in the manner specified therein, which may be useful or relevant to any inquiry or proceeding under this act. Now, my lord, subsection 2. Where any information or document has been received in response to a notice under subsection 1, and the prescribed income tax authority may process such information or documents and make available the outcome of such processing to the assessing officer. Now, subsection C, my lord. The board may make a scheme for centralized issuance of notice or processing of information or documents and making available the outcome of the processing to the assessing officer. Now, the board may make a scheme. Now, the scheme I have already placed before your lordship. That was the scheme.
This information which is come from whatever is available doesn't appear to be an information directly relatable to the SSC.
No, my lord. It is not directly,
Not
that is one,
directly, not directly relatable
no,
from the document. But what if this information is relating to some other person,
yes,
that Narendra Jain or whatever? it is?
yes,
During the investigation or calling for centralized issuance of notice and collection and processing of information of that Mr. Narendra, some information has come showing the connection between the present SSC and the,
we do not know that, my lord, because,
no.
Huh.
I am trying to understand the import or purport of this notification.
yes, my,
This notification, Narendra is not before this court. So this notification may be applicable to Narendra in this present format.
yes, my,
Some centralized notice, etc., may have been issued. We don't know.
yes,
Whether it will preclude any other authority to pass on the information to other income tax authority which are derivatives
my lord,
from that particular authority.
my lord. Since they have relied upon this explanation to CA,
I am trying to appreciate your submission. You are saying whatever information you have got, that information has come from someone who's not authorized to give you that information.
that is,
That's your submission.
yes, yes,
Now, what we want to know is, let us assume that he is not the authorized person under this scheme. But this authorized person, his authority has to be adjusted for the function described in the scheme, namely to issue notice for centralized issuance of notice, investigation, etc. Maybe he is not the authorized authorized authority. Maybe it is, as you say, the Commissioner of Income Tax Delhi. Now, does it preclude the Commissioner of Income Tax Delhi to share this information, whatever
will-
he may have got from Narendra?
no, no. If the Commissioner of Income Tax Delhi was the prescribed income tax authority, if he has collected the information
Hmm.
and if he has processed it, and if he would have passed that information with all the details to the assessing officer here, that would have been a different thing.
Will record that.
But he has not forwarded this information to us.
Yes.
My lord, they do not say that this information was received by them as per provisions of section 147 explanation 2A or section 133 6. They have, it is not their case. They have simply reproduced that section, presuming that it may be an information under that section. It is not their case that this information was received under section 133. This is one point.
Yes.
Secondly, my lord, at page 119, they say that the information has been received from Directorate of Investigation. They do not say that the information has been received from the prescribed authority under section 133C.
No. So therefore, your submission, when you use the term prescribed authority, it must only relate to 133. Is that the submission or?
That is my submission because section explanation 2 CA also refers to section 133C.
And in terms of this notification, director investigation, or
Not only the prescribed authorities,
CID did.
CIT Delhi, e-verification, that is. Now, my other submission is, even if this, supposing this information have been received from him, even then, my lord, it has to meet the requirements of two limbs of section 147. That is the 147 main section, recording of regions, reason to believe, and the live link with the formation of belief. And number two, that I have failed to disclose fully and truly all the material facts those are required. Those requirements will still remain even if the information is received from anybody. Those are the basic requirements. Those are the jurisdictional facts. Without meeting those requirements, the AO cannot assume the jurisdiction under section 147. This is my submission. Then, my lord, yeah. ये आपके पास चल My lord, they have filed their affidavit. Their affidavit in opposition, my lord. in para 5.
Hmm.
They say that the notice under section 148 was issued with prior approval of principal CIT, Guwahati 2. The notice was issued to the HSE based on a reason to believe that income chargeable to tax has escaped assessment within the meaning of section 147. Now, we only ask for a copy of approval that has not been made available.
Approval by whom?
Approval by the prescribed authority who has issued sanctioning, who has approved the issue of notice. We don't say that he had no satisfaction or etc. We only wanted a copy of the approval. That has not been provided to us.
Is it mandatory?
My lord, we have asked, so it was fair on their part to provide us the copy.
No, so either you say it is mandatory, therefore they are required to provide, or you say since they did not provide, there is no sanction.
We are not saying, we have not contested the approval. We simply say that we asked for a copy. It was their duty, they should
What I'm
have,
saying, if you say it was their duty, means duty cast under the act or the rules for that matter. All right, but you are not saying that there is no sanction.
we have not contested. Now, my lord, paragraph 6.
Yes.
That in response to the statements made in paragraph 8 of the writ petition, the answering deponent begs to submit that the assessee filed return on 27/4/2017 showing total income at rupees nil and the revised return on 8/9/2014. The assessee showed total income at nil. By filing the return,
Pursuant to the rejection of your objection, did you file your returns
no, we filed earlier.
earlier?
Because without filing the return, we cannot apply for a copy of the reasons recorded.
All right. So I mean, pursuant to the notice, you had filed a return.
Pursuant to the notice we have filed.
All right.
Then, my lord, para 6, he says that by filing the return in response to the said notice under section 148, the assessee company has participated in the proceeding.
Yes.
And then, my lord, then, just a minute, my lord. Then, my lord, in para 7, they say that in response to statements made in para 9 of the writ petition, the answering deponent begs to submit that it is true that notice under section 143(2) dated 23/5/2017 was issued to the assessee by fixing the case on so and so, 14/6/2017.
Have they stated anything with regard to this information? which they have received from Director Investigation or regarding their satisfaction that there was an escape of income due to the fault
My
of
lord,
the SSC, what is their stand here?
department stand, my lord. No, they have not stated anything like that. Their stand in para 6, 7 and 8 of their affidavit is that we have participated in the proceedings. What they mean is that since we have participated in the proceedings, we cannot raise the objection now.
All right.
My lord,
No,
In-
that at this stage is, what relevance has it got?
it has got no relevance.
So,
If they have no jurisdiction, they have no
that's
jurisdiction.
the end of the matter.
There cannot be a case of acquiescence or participation in the proceedings.
This perhaps argument would have held if you did not reply or furnish your returns, and then
Yes, yes.
prior to that, if you had
yes.
come to the report asking for a writ, etc. Right?
But
At
my
this
lord,
stage,
I, I have placed two judgments on this point.
no, but this is not relevant today. Why are we looking into this? Unless you insist that it is, I mean, how is it relevant?
It is not relevant.
It's not relevant.
When they have no jurisdiction,
So
it is,
let's skip this.
the jurisdiction is a creation
core
of
issue.
statute.
It's the core issue.
It's core issue.
That's it, I think.
I think all others are,
If there's anything more, you can edit in your reply after hearing the respondent.
my lord, I will just conclude then,
Yes.
because there is nothing more specific here. So, my lord, first,
We have noted your conclusions. Actually.
my
You have so essentially you say the reasons to be read as recorded by the assessing officer.
Correct.
No supplement, no presumption,
no,
nothing,
nothing.
not even by the court.
No.
Then it must have a direct or a rational connection with the
Materials available.
materials suggesting that there was escapement of income.
Mhm.
Then report of investigating officer per se does not amount to information.
Unless,
Coupled with the fact that even assuming it is information, he is not the prescribed authority.
that is one, my lord. My second argument was
Yes.
that the report of the investigating officer per se is not an information
That's right.
unless he applies his mind and conduct his own inquiries.
Correct. Then there can be a roving inquiry.
There cannot be a roving inquiry.
Then the duty of the SSC is to disclose primary fact.
Only primary fact.
Then this aspect was not dealt with by the AO while rejecting your objection.
Yes, my.
And then the notification which you say is they are not the prescribed authority.
Correct.
And of course, you say that copy of the approval of the sanctioning authority is not furnished. So that's all.
That's all, except that 147 has got two limbs. One is
That we have noted.
proviso and
Yes, yes.
my lord, after they make their submission, I can
Yes,
Your Lordship, this can be part heard.
when do you want to give your reply?
2 weeks, after 2 weeks.
What 2 weeks? We're in the middle of a hearing. What 2 weeks?
Thank you.
We'll hear you on 20. 20. You're available here, 20.
20th,
Otherwise, all the elaborate arguments we'll forget.
I'll be here.
We'll have it on 20. It's on 20. आ जाते हैं।
20th.
आप note कर लीजिए ना। Matter.
My lord, in the item number 26, that is WPC 7482, 2027. This reopening after 4 years, the proviso issue is not involved there. I'll make my submission on 20.
You, after you conclude your submission, a very short synopsis in respect of each of the case,
My lord.
giving the fact
Well.
where proviso is applicable, where it is not applicable. Heard, Mr. R. Goenka. Mr. Their argument, the right of reply after the argument matter be listed again on 20 for reply by the Standing Council Income Tax. Okay. Yes, 20. That will be kept part. It will be part.
This was the matter of the fruit juice.
Ah.
Now, my lord, apart from the other submissions which are, whether it is, which fall in this entry or not, I place before your lordship the notification amending the rates with effect from 1/10/2021 in respect to the same items.
Yeah.
Now, once, my lord, the items have been inserted as separate item and rates have been provided for in a particular date, the same cannot apply retrospectively because it was only with effect from 1/10/2021. Now, the period involved in this case is prior to 1/10/2021. As such, other submissions are there, but I may place one judgment of the Supreme Court, my lord.
These matters will take some time, so we can fix it for a later date so that we conclude the hearing at one go.
There only. Oh,
Hear for the respondent.
here for another case, 32 to 3.
Subject to
If you lordship just
Huh.
we'll look at one paragraph, no?
judgment.
Compilation I've given. The last page, my lord. Page 114. Paragraph 14 below.
Yes.
15. In the instant case, the SSC had filed a classification list effective from 1/4/1993, classifying the single panel circuit breaker under heading number so and so, and claiming consistent readability of 5% under notification number so and so. The said classification list was approved by the Judicial Assist Commissioner on so and so. Thereafter, the SSC cleared the said goods in accordance with the approved classification list. When the approved classification list was proposed to be revised to reclassify the single gate breaker under so and so, their effect. Such reclassifications take effect only prospectively from the date of communication of the so-called notice proposing reclassification. In the instant case, the so-called notice was communicated to the SSC only on so and so. Therefore, as rightly as by the learned counsel for the respondent, the reclassification can take effect only from such a date, and according to defense duty can be amended only from that date.
Yeah.
So we want to, when the amendment has been made and the new entity, the specific entity has been inserted, with effect from 1/10/2021, it cannot be said Parab, that that item had earlier also was taxable at a particular rate in the residuary item.
Here, where is the notification?
The notification. You'll also find at page 277 to 72.
Which writ petition?
Similar WPC 53 5340. I think 4
5340.
my lord.
Yes.
Two 72, you'll also see.
Yes.
Notification dated 30th September 2021. And you'll also may kindly turn to page 277.
Yes.
Entry 12B, my lord.
Yes.
Carbonated beverages of fruit drink or carbonated beverages with fruit juice.
Yes.
And this has been made effective from 1st 1/10/2021.
And
The periods are prior to 1/10/2021.
where is the impugned order?
Your impugned order is also fine. Page 146. Okay. You'll also find at page 284.
Yes.
And you'll also find the period which is mentioned. So-called notice of source and period. So notice, nothing. My lord, at page 279.
Yes.
You'll also find the period. July to 2017 to 2018.
Yeah. No, what is the order passed?
Well, already lordship, they have not considered the notification at all. It was placed, but it was not considered.
What is the ground here?
But at the ground, they are saying that no, this is a fresh judicial assumption. At page 291. Second paragraph, my lord. Upon perusal of the submission stating the special entity to prevail over the general part, as per the general rules of interpretation, it is observed that the same is not accepted principle. Same is an accepted principle. However, in the present case, the question of classification under item so and so, as provided by the taxpayer, does not arise, considering the fact that the subject product fits well with under the so and so. For the fact that upon proper classification of the subject product under so and so, the question of classifying it under the residual income of so and so does not arise. Upon a perusal of the submissions stating that upon the application of the common parlance test, the subject products are classified as so and so, it ruled out, considering of the fact that the subject product uses fruit juice concentrate. You'll also kindly note it. It says that because they are using fruit juice concentrate for manufacturing of the product, as determined on the label of the product, and remains a known fact that the industry refers fruit juice, a fruit-based juice-based drink, differently from fruit juice concentrated based on drinks. Hence, even after applying the common parlance test, this so and so, they are saying that it is fruit juice concentrate based drinks. Now that was the entry which was inserted.
Prior to that, what was the entry?
Well, there's entry which was there, the main entry. I reproduced in the petition. Entry to I'm giving the middle of this one. You'll also find it GST tariffs at page 160. Double two.
Yes.
You'll also find page 164. Fruit pulp or fruit juice based drinks.
So this, according to you, it is this entry,
Milo.
and according to them,
That this is fruit concentrated, this one, below.
what is the entry?
Well, the entry which is there, the last, which has been added. Inserted below. It is carbonated beverages of fruit drink or carbonated beverages with fruit juice.
No. In this, in the earlier schedule,
Milo.
other than this entry 48, there was no other entry.
Well, there are other entry, carbonated, there is no entry.
And the impugned order was passed by the authorities, placing reliance on this particular.
Because they are saying that this will not fall in this one.
This will not fall. So
Oh.
it will go for what? Residual.
And that's residual entry, my lord.
Where is the residual entry?
This is 22909990. But they are saying 2299. Huh? 19019. Huh? Huh? कितने percent का है वो? 15%. 2201. अच्छा, 4. My lord, at page 106, it is others, my lord.
10,
22021090.
page number
106, my lord.
106.
My lord, that I've given in the written submissions, my lord. Reproduced from the, in the same, my lord,
This one?
106 of the petition. In the petition itself, my lord.
Writ petition.
My lord.
106.
106.
Yes.
They are saying it will fall under 220210.
10.
My lord.
10 or 90?
This is 10, my lord. Second. Nine zero question, no? They are saying 220210.
No, they say it is 22029920.
My
Oh,
lord,
sorry, that is ruled out.
you'll also find it page 285, they are saying. Para 7.
I think it is 293 also.
My lord.
293,
Page number 293, my lord.
293,
My lord.
second bullet point,
My lord.
actual classification.
My lord. The second bullet point, my lord.
Yes,
293.
293. third line.
The prayer for the so-and-so is being rejected and the fact that they have not paid so-and-so circumstances, the prayer for subject matter fusion and accordingly it is organized. In melody, you'll also find that they are saying that it will fall under 22021090
90.
and not 2 zeros. The question is that, the regions for which they are saying that has been amended only into 2021.
Their contention would be that this item does not fall under the classification that you have projected,
Right.
number 48. So since there is no other classification, it goes to the residual classification.
Well, that's why we have given the judgments also
Right.
that this item, in fact, is a fruit-based. With the Supreme Court has also said this is a fruit-based. They said because you have used the carbonated water and all those things, this will not fall in that one. Now, with the carbonated water, the entry has been made separately, subsequently. So if the carbonated water entry has been made separately, then they cannot say that because carbonated water was used, thereby it was not following this one. The fruit-based, the apex court and all judgments below has said, in the case of other cases also, that this fruit-based similar use items will fall under the examining under the same entry 229020 below. In the judgments, they say that it will fall in that entry. The tribunal held it in the favor of the SSC, and that was upheld also by the Supreme Court. Now they are saying that this was not in the GST law, but the classification, the tariff was the same. The tariff was the same earlier also. The entry, it is GST also, my lord, and earlier also you will be aware. Under the VAT also it was in the excise and customs. Now under that, if the 2290 this classification was there, then only because GST law has come, and GST law is also the classification is under Central Excise Tariff Act. So it cannot be said that because GST tariff law has come, so it will not apply. How it will not apply? And the region only is given that carbonated water is there. As such, it will not fall in this one.
Yeah.
And when the entry has been made, my lord, if your lordship is look into page 89, the fourth paragraph, my lord. And whereas even under the common balance test, determining as to how a product is in question is marketed and sold consumer large, in your case, the products in question are being marketed and sold as carbonated fruit beverages.
Yes.
So the question, first of all, will arise for consideration for lordship with that, my lord. Whether the carbonated fruit beverage will be a fruit-based drink or not. Fruit-based drink and fruit juice itself are two different things. It is fruit-based drinks, not fully fruit juice. The water, carbonated, sugar, etc. are added. The fruit base is the fruit juice, which the Supreme Court has also held.
Which judgment to refer?
Yes, Appellation. See page 1. entry was, my lord, in that case, item was fruit juice based drinks. At page you also may see the note itself, my lord.
Yes.
The entry is mentioned. And Appy freeze along with carbon dioxide as preservative. Classification of the accredited branded soft drink post 2007 entry so held incorrect. Sold drink remained fruit juice based drink.
Yes.
You also see page 36. We have already observed that items which have been grouped in subsection so are all those items which are higher tax slates have been fixed. Looking into the nature of the goods, we well settled that all tobacco based goods which are now included in so are dangerous to health. The use of the plastic, polythene, etc., which have been also been adverse effect on the health environment. In contrast to the accredited branded soft drinks, which includes in section health drinks of all varieties are included. NT 22 amended accredited branded soft drinks, which are referred to in section 6, cannot be drinks which are health drinks. Fruit juice-based drinks can be regarded as health drinks as compared to the other accredited branded soft drinks like Pepsi, Coca-Cola, etc. We are thus of the opinion that the appellant has successfully proved by relevant scientific and technical materials that the product in question, Appy Fizz, is a commodity which is fully covered by item number so. The High Court discarded the scientific and technical opinion with regard to the manufacturing process and contents of the product. The order of Food Safety Commission was also discarded, which is relevant for the considering the nature of the content product. The adjudicatory was relevant, at least on the spec that Appy Fizz is not accredited, which was discarded by the High Court as well as the Commissioner of the Commissioners. Now the CSET order, my lord, which was at page, at page, you also may see page 69.
$69.
My lord.
Yeah.
This was the, my lord, case which was, my lord, ultimately upheld by the apex court.
In this parley.
Parley, my lord. You also see para 5. As the product in question is juice-based drink, therefore rightly classified under subheading 2202999020. And you'll also see next page the entry 229020 fruit pulp or fruit-based drinks. The same entry.
Is the entry here?
The same entry, my lord. 2290. I'm a petition notation. I'm going to page the at page 106, my lord. Double 22029920.
What is your product? What is the name?
Name of different, my lord. I've given the names in the petition itself, my lord. Different items are there.
Okay.
But this judgment, they are saying, my lord, because it was in the Kerala VAT Act, and as such is not applicable.
The entry appears to be the same.
Entry is the same.
You file your counter.
We have filed a counter, we have given reply also, my lord.
My lord, in WBC 5342 of 2022, we have filed one affidavit in opposition, my lord.
We have also submit reply.
We have submitted reply. Yesterday, we have submitted.
So that's any other judgments or any other,
Those other judgments are on the same issue, my lord. I've given the judgments.
what is that, 534?
Page, my lord.
No, the where the affidavit has been filed.
My lord. 5342.
42.
What is their stand here? There's no reply here
Reply extra. We have filed yesterday, my lord.
yesterday.
Now, if you also look into my lord, page 189
The reply,
of the opposition, my lord.
180.
9.
It ends at 188.
84, no, I'm sorry. 180. In the middle, my lord, furthermore, you will also quote him, Lord. Furthermore, the contention of the petitioner in having completely ignored the two notifications does not find merit to the present case for the fact that the two notifications were neither a basis of issuing so-called notice, nor was the basis of issuing the demand notice to the petitioner. Now, my lord,
What were the two notifications?
this amendment, my lord, the entry has been made. Now, they say that no, this was not a basis of issuing the so-called notice. When after the so-called notice, my lord, the notifications have come and we are placed before them, how they can ignore, say that no, this was not the basis of so-called notice. That means tomorrow some amendments will be made after the issuance of so-called notice or
This was after the notification.
no, subsequently. And in the hearing, we placed it. It will also call for
Show cause was issued subsequent or prior to the
prior
Subsequent 2022.
or stock is not subsequently.
subsequent?
And we placed it before the authorities. And they are saying that this was not the basis of the so-called notice. Simply, this is the reply. And about the judgments of the below. You let me see. They are observing below that. Page 193 as well as below that. About parlay they are saying below. And you will also see page 196, paragraph 15. And you will also get below.
Para 15 of the judgment.
Below paragraph 15 of the opinion of page 196.
1515,
1.5, at page 196.
yes.
The deponent denies the statement made in paragraph 22 of the opinion of question and dictates refunds the statement made in 15 of the question.
No,
My lord.
para 15 here is one.
Oh, this is my reply. I'm sorry. What was the opinion of question? Opinion of question of the below the opinion of question first, thereafter reply. You'll also see 179, paragraph 23.
Yes.
With regard to the statement so and so, the deponent states that the said case cannot be considered relevant to the present case wherein the said case was provided in different specific items, whereas the present facts of the case are totally different. Hence, the contents of the petition relying on the case cannot be said to be the following merits of the present case. So the notification, they are discarding that this was not the basis of the stockage notice. And the judgment, they are saying only that this is not applicable. But the others under which they are classified was the same rate. Now a specific entry has been given. If it would have been falling under the below this one, because it fall under below was falling under 22909020. That's why now they have taken out and made it specifically taxable at this at the higher rate.
Okay, in this writ petition where the affidavit is filed,
My lord,
is there a reference to the schedule? Tariff?
they have only not scheduled. They are saying that the
No, is it enclosed in
no.
any of the annexures? No.
In the affidavit of question, no. The
No,
petition we have annexed.
not affidavit, in
The
the,
petition we have annexed, my lord.
in the writ petition.
Yes, it has been annexed. That you will also find at page 160. Yes.
No, the classification, the heads here,
Yes, you will also find it
156, is it? If you come to 15C,
My lord.
15C,
So in the second petition, the schedule has been annexed here.
So if you come to 156 of this, I can tell you.
156 was.
One.
So that is a part of the reply, my lord.
No, that's a part of the
So
impugned
course, but our order, my lord,
order, impugned order.
my lord. But the entire schedule I have annexed, my lord.
No, that's okay.
My
I
lord.
think this could be enough.
Yes,
Uh,
my lord.
This brings out the schedule.
My lord. 229090 others
Uh,
and 22,
So they have classified it under 9090.
my lord.
And according to you, it should be
9920,
9920.
my lord. 22 fruit juice, fruit pulp or fruit juice based drinks. And exactly the same, my lord, entry was interpreted by the apex court.
We are ready to dictate.
My lord, both the arguing consists are provided in different courts, my lord.
You are there.
May I prefer taking up this matter in the next week, my lord.
Yes, Doctor. Sir.
Tuesday, my lord.
Keep it for Tuesday.
My lord.
Try to prepare a written, small written submission also. I think next matter,
दोनों मैटर एक ही है. With Tali.
next matter, I think Lordship will have to refer it because no practice there.
Next matter.
The series below, that was the case of the machine capacity. And the earlier also so-called notice was issued, the Commissioner of Appeals set aside the order. In spite of that, the fresh so-called notice was issued and the order has been passed.
Yes, Mr. Kyal is elusive today.
He was there, he has again,
He has gone to some other court. He's on legs.
So can't be helped because these are matters also fixed, partnered matters.
Yes, Lordship, this matter was partnered. According to his instruction, matter may be fixed after a week.
After a week.
Yes, or on 20 itself.
20 will not be convenient.
19, my lord.
We can keep it on 25.
Agatha Jama. 25, in fact, I have to go to Agatha.
All right, then
28 Friday, my lord.
28.
My lord.
28 may not be convenient because it's the last working day.
Well, then let it be on 19, my lord.
19.
My lord.
All right, 19. It's on 19th. एक कौन सा है? 32 to 35.
My lord.
Yes. All right, 19th. It's on 19th.
I'm obliged.
Much obliged.
Completed argument, when Mr. Talukdar was supposed to reply. He was here, but he thought the matter will not reach.
Our courts rise at 4:45.
But I don't know.
Perhaps he's still
We
in the
understand
belief
that.
that it will rise at 4:30.
Your Lordship has heard the matter. On
We have heard, we are ready to dictate this order today. If you can find him, we are here for another 10 minutes. If he's there, we can close the matter. Yeah. Yes.
Lordship, although is a small matter, the rejection of refund application by the department, stating that it's a time part. In fact, this matter was heard by Lordship during the corona period at length, but could not be completed. Today,
We had passed some orders in some other matter.
Lordship has passed the order. It's almost similar, but slightly facts are different. I would like to place the facts before Lordship. Would
Do you
like
have
to
a copy of that order?
Yes, Lordship.
It's available. And proof that it- Here, it is similar. There was a delay in filing refund application. The department has rejected, but before rejection in this matter, the petitioner was granted opportunity of being heard. After that, the matter was remanded. In my matter, that stage has not arrived. In fact, they have proceeded for assessment. Assessment was not completed, and it remained as it is. And subsequently, they presume that since assessment is not complete, we presume as self-assessment, and as such, the refund application is not within time period. The Lordship has remanded back the matter for consideration by the department. And in your case, what has happened?
In my case, Lordship, they had proceeded for audit assessment, but they did not complete the assessment. And I waited for the period of 8 years because the final audit assessment and escape assessment, the provision provide that they can do it up till the period of 8 years from the end of the relevant assessment year. I waited for awaiting that some orders will come out. And after that, when I filed my application, refund application, they say that since audit assessment was not completed, so we'll presume it as self-assessment.
We'll take it on 19th.
Lordship.
Inform the others.
So he was admissible, but today I think 19. But
No?
Date may be given. Date of the deal. एक तो डेट दे देना भाई मंगलवार मंगलवार हाँ ठीक है वो डेट এটা দিয়ে দেবো ও ঠিক আছে হ্যাঁ কি করবে নেথায় গেলে 10 মিনিট আগতে দিতে 20 क्या बार होता है एडमिशन में आता है ना आगे एडमिशन
Thank you.